7807 in the matter between the economic freedom fighters and the Minister of Police, sorry, Minister of Finance, and 4 others.
May it please the court, my name is Advocate Kasiboto from the Tulamela Chambers, and I appear for the applicant along with Mr. Masipa, himself and Slavic attorneys. As a court please.
Justice Erasmus, may it please the court. I think I saw a slight look of surprise on Justice Erasmus's face. On this occasion, I'm not for the economic freedom fighters, as you have become used to. And indeed, I'm not leading either Mr. Kasiboto or Mr. Masvikwe on their behalf, as I've done before. On this occasion, for the record, my name is Premet, initial K. Justice Nuku, Justice Mayosi, I don't think I've appeared in front of you before, and I appear together with my junior, Mr. Mfeka, on behalf of the Minister of Finance.
Thank you.
As the court pleases, if you just indulge my junior to just get this for me. My apologies.
This court starts on time, and I expect people to be ready on time. I was delayed by 3 minutes this morning. I don't like that.
My apologies.
Let's shoot.
Perhaps just by way of housekeeping and getting a directive from the court, we've received this morning a Rule 30 notice.
I'm not going to, you can start, you'll deal with everything, and Mr. Premet, when he takes the floor, can deal with everything.
I'm indebted.
We're not going to have sideshows. Let's just get straight to the issues at hand. I thought 1.5 hours will do. We're going to take the customary tea adjournment, and we'll plan our day. Subject to the argument, we need to give an order by this afternoon, early evening, as the increases, if one could call it that, becomes effective at midnight. We're well aware of the timelines. Now, whilst I'm talking of that, and I don't want to take time with it, and you will have no right of reply. We received, the case lines were updated very early this morning. Last one was at 7:07. That's when the respondents' heads were uploaded on case lines. We received an email shortly before we resumed from Mr. Nene with the respondents' heads. I don't know about my colleagues whether you have received the hard copies yet of the respondents' heads. Received them. And whilst I'm on that, I expect practitioners to treat our staff with respect. I don't want to hear stories of people giving the registrar's lip, as happened this morning. Not specifically referring to you, Mr. Kasiboto. Right.
It is not an excuse. Perhaps if I could just respond in a sentence, my lord, and obviously this is an obligation I hold to the court and to the staff as to what transpired on our side. Case lines was done as of Saturday, I'm told by my attorney, but hard copies were handed in, and then case line was on again this morning, as I understand it, which is why it's been updated.
Let me correct you. It was put on court online, but it wasn't bundled. The full bundles only became available this morning, but I can see on case lines when it was uploaded. But it's of no moment. It's here now. We're ready to rock and roll. So let's do that. No, have a seat.
Do you need hard copies? That's all I wanted to ask.
You can give it to the registrar. We're wasting time now.
Thank you, my lord. May I please use your hand up?
Carry on, Mr. Kasiboto.
As the court pleases.
I've got your heads open in front of me. I've got both hard copies and a soft copy. Yes, thank you.
As it is the presiding judge. What I want to start off by doing is setting the parameters of the debate, because there seems to be a misconception of the application that this court is seized with. What this application is not about is a review and setting aside of the decision by the minister. Neither is it a constitutional challenge to Section 48 of the Customs Act. It is not that. What it is an interim relief that the EFF seeks under the rubric of Sitlukelo as developed over the years. So in essence, our application is a noble one. It simply asks this court, have you made a case for a prima facie right that is under peril or is being harmed, where the balance of convenience warrants the interim order, and that there is no substantive remedy in the long run? That's the sole question this court has to answer. Perhaps then the challenge and the misunderstanding of our case stems from a full appreciation on the EFF's part that we must give a judicial pick into Part B to justify the granting of the interim relief. Because as we all know, if there are no prospects of success at Part B, there's no reason why the interim relief should be given, particularly one that curbs executive function. So we appreciate that. We do no more than simply give you a peek. And what we're submitting is that all the court has to do is, we don't have to agree with us on the Part B issues, but that you see how we could prevail in Part B. So that's the extent to which the reviewability and the constitutionality of the relied upon provision becomes of relevance. It's to that limited, humble scope.
Do you have to foreshadow a Part B?
We have to foreshadow Part B, and that's all we do.
And what does that entail on the papers before us?
How we, and I was hoping I'd get there, Chief, let me get there now. What we do at paragraphs 11 and 12 of our founding affidavit, which appears on indexed page 9, that's where paragraph 11 appears.
Mm-hmm.
What we said, paragraph 11 and 12 is, we've written a letter to the minister asking specifically what instrument he relies on to make the decision. We give him 48 hours. He does no more than acknowledge receipt of the inquiry. Has not responded to
If
date.
I may interrupt you, that letter that was attached, is that the final letter of the three? Must we accept that's the final letter of the three? Remember there were three letters written.
Indeed, I'm referring to the one to the minister himself, not to the speaker and the committee. Because we seek no remedy against them, we saw no utility in bundling up the application with irrelevant material. So the one that I'm making reference to, which is EFF 2, at page 48 is the letter in question, which is the letter to the minister. So we asked the minister to respond within 48 hours. All we got was an acknowledgement of receipt, asking a simple question, firstly obviously raising the issues that serve before this court, but importantly, what instrument are you relying on? Because that will inform our position. Fast forward to where we are now. The founding affidavit was deposed outside of any knowledge of what instrument the minister will rely on. But the EFF has always known there's no instrument that empowers the minister to do what is done. We then in paragraph 11 and 12 say, to the extent the minister, this is 12 specifically, 11 foreshadows, 12 specifically says, there's another matter, we call it the VAT matter, hours before this court with my senior arguing it, and the minister concedes on the 11th hour of judgment. There's Part B to that application, which challenges exactly what we say we challenge at Part B here, where the minister relies on a provision in the VAT Act, I'll call it for simplicity, and Part B then challenges the constitutionality of that provision. We say at Part B, if the minister will purport to be exercising his power in terms of legislation, we will have this matter consolidated with that one, because it's the same question of law, at least the test is the same, against the same minister by the exact same party. So we foreshadowed that. That then explains why it does not appear in our notice of motion. We did not know. But be that as it may, we're entitled to supplement our papers at review in any event. But what is crucial is that it is clear, I respectfully submit, that the affidavit foreshadows all of this. Because if you read the founding affidavit in its totality, you can see the permeating and constant theme. The minister is acting unconstitutionally, acting outside of legislative oversight, and any power that he purports to exercise justifying that conduct, notwithstanding the no taxation without representation principle, whatever provision that may be, is in itself unconstitutional to that end. We then say Part B, if that's what the minister seeks to do, which in fact does in answer, then it triggers our Part B application, both for review and setting aside, and or a constitutional challenge to Section 48 that we now know, as of yesterday, the minister purportedly relied upon.
So, Mr. Kasibota, can I just ask? So, at a number of places in your affidavit, you correctly acknowledge that a consideration by this court must be made of your prospects of success in Part B in order for you to succeed in Part A. You've just in your argument referred the court to paragraphs 11 and 12, and I have a difficulty with those paragraphs, because paragraph 11, 1 refers to the VAT challenge. That is not before this court. Those papers are not before this court. I personally don't know what you said in the founding affidavit in that matter. In paragraph 12, what you say is, at this stage, the EFF is in no position to definitively set out to this court what the nature of our Part B would be, because to date the minister hasn't responded. So it seems to me what you're doing in paragraph 12 is to say to this court, we are unable to give you a peek into Part B. Stop. And that's my difficulty. And in fact, the founding affidavit proceeds to give no such peek into Part B. So, if the founding affidavit doesn't deal at all with the content of Part B, the irrationality relied upon, the unlawfulness relied upon, and so on, is that omission, which is acknowledged in paragraph 12, not fatal to Part A?
Thank you, my dear. Perhaps as a starting point, let me be clear, there is no concession that there is such omission. Just to restate, 12 says, because the minister has failed to respond to the letter informing the EFF what provision is going to rely on, we are, as at the deposition of the founding affidavit, unable to tell on what basis the minister makes the decision, because it can be accepted. You can't do it just simply by announcement through tabular budget. We then ask him what instrument do you rely on. Now, there's no response as at the deposition. We then say, whatever instrument the minister will rely upon, if he's relying on a provision that is constitutionally assailable, we will then go to Part B. That's how I understand paragraph 12. We then have, for the first time, an indication of what power the minister relies upon in the answering affidavit. So for all intents and purposes, then a case is made there, and in that sense, you can read the answering affidavit as a founding affidavit, if you will, of a defense, if that makes any sense at all. We then, in reply, then deal with the issues of the constitutional invalidity following the answering affidavit. That's what we do in the replying affidavit. That is what we do in the heads of argument. And we go
quite extensively, perhaps a bit more than we should for a Part B, where we say, firstly, we rely on the principles of New Africa, Shuttleworth, which is quite ironic because so do they. And then we say the fulcrum of those principles is that the minister may not exercise plenary power or impose tax, which he accepts he's doing. So there's no dispute around what he's doing. He's not suggesting that I'm regulating. He's saying I'm imposing tax for purpose of revenue following my failure with the VAT attempt. He says that himself. So he says, because I failed in VAT, now I'm going to charge fuel. He says that in his budget speech. We then say that's a plenary power that imposes tax. And in terms of section 73, 75, 77 of the Constitution, that must be done through a money bill. Absent that money bill, then he cannot do what he proposed to do on the very same New African Shuttleworth decisions. Then the retort to that argument is that, well, there's 48(6), which is the parliamentary oversight that we're complaining about. But with respect, 48(6) does not mandate the minister to take the matter to court. It doesn't. It simply says, if Parliament makes nothing of the decision, then it will lapse a year following the decision in which it is made. There is no positive duty for him to actually present it before Parliament. And what is crucial is that what the minister is doing, and I think there's common cause here, and I'm subject to correction. What is clear is that the minister is imposing tax. Section 77 explains what a money bill is, which is the only instrument you can use to impose tax. I think we're at Eden, at least to that point. And then it sets out what process must be followed to introduce a bill, a money bill. And the 73 says only the minister can do so. So in effect, if his amendment we accept is an imposition of a tax or a fuel, he calls it both at page 7 of his speech. If we accept that's what he's doing, as he says is what he's doing, I'm increasing revenue in light of the fact that I couldn't persist with the VAT Act, that's what he says. Then he can only effect that amendment through a money bill, and only the minister can introduce that money bill. That is constitutionally speaking, so no one can force the minister in terms of 48(6) to present this bill. Now, the mischief is this. What we must accept, because that is what we are told we need to do in New Africa, we must accept the context within which this power is exercised. What is the political context that informs these decisions? We're in an age where there's no majority ruling party in Parliament. There's GNU politics, and that is precisely why he struggled with the VAT Act. I think we can all accept that. Now, if the minister is persistent, as it seems to be, that he wants to have this fuel levy increased, what stops him from just simply not presenting that money bill to give effect to this increase, let it lapse come the end of next year, and if he wants to increase fuel again, he does the same exercise. Because by operation of law, failure of Parliament to deal with it does not nullify his decision. So for all intents and purposes, he would have validly charged the increases 16% for petrol, 15 cents, my apologies, for diesel. So that's the mischief we're dealing with. And we cannot adjudicate matters on the basis of the bona fides or purported bona fides of the minister. We must be able and open to having a rogue minister in the future who will equally exploit what I'm suggesting now, for example. The simple point is you cannot have uncurtailed power. What we're also not told is precisely, and this is where Harris' judgment comes in, precisely which of the 5 subparagraphs, sections of 48(1) is the minister relying on. He doesn't tell us.
Sorry, let me just interrupt you, Mr. So when the application is launched, the applicant is unable to give the court a judicial pick, and then the first respondent answers and says that he relies on Section 48 of the Customs and Excise Act. And he says that that provision is a provision that has been in existence, that empowers the Minister of Finance to amend schedules to that And all that is happening here is an amendment of a schedule, which is already in existence in that country. And so I want to understand now, how does the applicant deal with that in the sense of giving an indication to us as to what the challenge will be? Because the Minister squarely says, this is the enabling provision that I relied upon. It has been used for so many years in the past. In fact, the applicant at some point in time was happy to propose a further reduction, which kind of indicated some acquiescence to the availability of this way of doing things lawfully. So what does the applicant then make of that? Or what should we make of that?
Thank you very much.
So, Mr. Gaswood, and linked to that, given that context, that historically this mechanism, Section 48 mechanism, has been invoked in previous increases, decreases, and so forth, whilst the applicant was already represented in Parliament. My question is, what is that you couldn't give the court a judicial peek into what you would rely on, because you would have known what the minister was going to invoke, because he's invoked this before?
In fact, 7 times whilst the applicant was in Parliament for an increase, and once for a decrease, where the applicant's argument was on the papers, but goes slightly lower.
Thank you, Justices, for the questions. Let me start with a basic premise. Okay, let me first even take one step further. So we have responded, Justice, in the heads of argument and in the replying affidavit on what the constitutional difficulties are for Part B. We've done that.
Now I'm asking it because I'm asking it that I've not had the benefit of going through the, so I would appreciate it. Just give it to me so that we can engage on if there's something that I would.
Absolutely, Justice Nugu. Then I may perhaps misunderstood your question. I'm happy to do that.
You see, this replying affidavit was only loaded this morning at 7:43. That's when we became privy to it. 7:43.
The reason?
And most of us must have been traveling into the office at that time.
The reason for
so
that...
maybe take us to the paragraph, and you can give us the case lines reference so we find it easier. It's in 10. So if you give us, it's bundled under 10.
There's no case line number. Thank you, Justices. I'm asking my junior to do that exercise. But what you will find in the replying affidavit, case line 029-10,
I think for me it would be easier because the replying affidavit is a few pages. You can just give us the paragraphs.
Thank you, Justices. Just to explain why the reply is late, the answering affidavit came 3 days after the date that was given by the applicant, and reasons were given by the responding for that. Whether they good or not is neither here nor there.
But if you want to go there, we can. Because what happened here, let's go there because we want to challenge my brother on certain issues. So let's meet it head on right now. Because there is an urgency challenge here. The client becomes aware of the increase, and I deliberately don't add in whether it's a levy or a tax measure or a tax proposal, use any of those technical terms. Let's just keep it as increase for now. On the 21st of May, 26th of May, 18 something, first letter. That letter is retracted during the course of that evening, and reasons are given. Take it, a second letter gets sent. This is now the dates issue, was the first problem. Then it gets retracted again, then it's a calculation problem. That's why I asked earlier, this is just not the final letter, because I haven't seen the other letters. That gets transmitted to the minister's office at 9 o'clock on the evening of the 26th. The email links are on the papers. Next morning after 9, receipt is acknowledged. We're now sitting on the morning of the 27th. Morning of the 29th, these papers are issued. Yes, there were circulation of the papers the day before amongst the parties. Gets officially served through Court Online and the systems provided on the minister's office at 13:10 on the 29th. He's out of the country. Tells us that. Gets given a timeline, respond by tomorrow afternoon 5 o'clock. That would have been Friday the 30th. Then you file, so that's now 10 past 1, 5 o'clock the next day, 27 hours. Then you file your affidavit by Saturday afternoon. Of course, I'm busy driving back from where I was. We need to constitute a bench urgently. Now we're trying to prepare on our side because papers were filed. So he gets given that period. Now we know what the rule says about timelines, etc. Let's not go into the detail. He returns to the country on the 1st of June. The proclamation is gazetted on the 2nd. Files his affidavit. All of us are being put under pressure by your client because they had the 5 days before. That's being argued by the respondents. Then we are expected to prepare as a court. Now Mr. Premier knows that we bumped heads on timelines like this in the past, and he lost. And then, of course, by Friday evening, we've constituted a bench. All three of us, out of other work. We prepare. Yesterday, in the afternoon, the reply was sent. It was only loaded this morning when it showed on case lines. But I had a copy because my registrar was on your attorney's case. So it came in the afternoon. No, the ministers came in the afternoon. The reply I only saw this morning. That's why my brother didn't see the reply. And then I realized this morning when I got to the office the heads of argument were also uploaded. And they were also uploaded this morning. He wanted to deal with that the minister was late with a day or two. Because we can engage on the urgency. But it doesn't make sense in a matter like this just to show you the door on urgency if we can deal with the other issues. Not that Mr. Clement will not be allowed to argue. So it's not only you telling me that you didn't comply with your self-imposed timelines. It's about treating the court with respect as well. Thank you, Mr. Kasipati.
As God pleases. My Lord, I have no intention or insistence on bringing urgency if the court is not inviting me to deal with urgency.
All I sought to do was to say the time frames were changed as per the notice of motion, and I don't want to get into the details of that. I was just simply trying to deal with that issue, and my apologies if the court took umbrage with that. It was done in good faith. In response to Justice Snow, so the first point I had made is that if you have regard to the replying affidavit at 010-13, you will see a heading there numbered Roman numeral 7 VII.
So on prospects of success are overwhelming.
At Part B.
Heading. Yeah.
So
it's paragraph 31, which is 12 of 26 in the affidavit, and it's 010-13 on case lines reference. I'm just reading it out aloud, Mr. Kasiboto, because my colleagues doesn't necessarily have the case lines open, but the hard copies.
And if I could just give you the heads reference, if my lordship is minded to read or have consideration of both. Under pages 054-48 of case lines, these are heads of argument. The heading there is Prospects of Success in Part B. So that's where we deal with the prospects of Part B.
Paragraph?
From paragraph 73 of the heads of argument. And perhaps I'll pause for a second for the court to orientate itself and to direct me to address it further.
Heads of argument, paragraph?
73 at case line 054-48.
But on the replying affidavit, it's paragraph 31, right?
Indeed, Your Lordship.
But that does not really explain to me what the problem is with that mechanism that Section 48 provides for. Because at 31.1, the reference is made to the budget speech. I think the minister says that the budget speech is not the one that does the imposition of the fuel levy. It is an amendment of the schedule that is in existence. So we have a schedule that is there to the Customs Act that he is merely amending. So I think if there is any offense, that must be the offending, but not really the speech. Or am I missing something?
Justice Nubu, let me answer the question, and I had a whole list of the ones you asked me. I'm hoping we'll get to answering all of them, so I'm not avoiding them at all. And the searching is not of desperation, I'm diabetic. So,
I can't see from a distance, so you are fine.
An amendment is not a mere amendment with respect, Justice Nubu. What it achieves is what matters. So to use the word amendment instead of passing money bill to increase levy are not necessarily two different things. If the net effect of that amendment is to do the same thing. We are contending that is exactly what the minister has done. So it's not a mere amendment. Its consequence is the consequence foreshadowed by Section 77 of the Constitution, which says if we impose a tax or a levy, which the minister says I have done, then you must do that in terms of a money bill. So if he achieves that...
So is that to say that for the other years, this thing has been done incorrectly? Is that the gist of it?
That's the sum total, and there's nothing wrong with the constitutional challenge for the first time. There are many laws in this country that were unconstitutional. They find their way to the court, declare unconstitutional, they are corrected and move on. We can't, on the basis of it's always said...
No, I'm just trying to understand that now the applicant says that, no. That's not the way to do it. You may have done it and gotten away with it, but it's not the argument.
Indeed. And this is quite strange to suggest that the EFF can just cloak a provision.
But this part, I mean, there's very few, there's not much which is being said on the prospects of success there to demonstrate why it is that that mechanism falls short, because the minister explains there that there is this mechanism, a gazette, it is subject to parliamentary oversight, there is a continuation provision, it may be amended. I have no final word in this process. The final word is with the parliament.
And understand.
And so if the court intervenes at this stage, it will be mid that process. And I don't see the engagement with all of that to demonstrate that there might be a problem, which then will be dealt with in Part B, in respect of which the applicant says it enjoys prospects of success.
As the court pleases, Justice. The first point I wanted to make is an argument, and I don't want to leave it undealt with in case it carries any weight. The EFF so-called acquiescence with that process 7 times before cannot now cloak an unconstitutional conduct as constitutional by acquiescence. It just simply cannot be. In dealing with the question of the prospects of success, we understand the founding and an answering and a replying affidavit to an exposition of the factual disputes in the full context factually. There seems to be no disputes as to the facts. What our prospects of success are in Part B is a legal question, and therefore it requires legal argument. We do far more in the heads of argument dealing with that legal question. We took a position that for an urgent court, what we do not want is to argue in a founding affidavit, argue in heads of argument. If Justice Nuku's concern persists even after taking it through the heads of argument, then I'm happy to deal with that contention at that point. But the upshot is
more fully in the head.
Yes, and the case reference that I've given earlier is from paragraph 73 of the heads of argument. So we deal again with that question, but in legal argument rather than fact.
Because you say it's a legal argument.
That's the point, Justice. And I also want to deal with some of the questions that arose, then I'll be directed where else the court would like me to go, but I think these are very important. There seems to be an acceptance that what will happen is that this decision by the minister will serve before Parliament.
So it's paragraph 73 until?
It goes on and on up until 83, and there are other references specifically dealing, and I'll take you to them, but 73 should suffice for now, Justice Nuku. And the point we simply seem to make is, it is not a foregone that this decision shall be before Parliament. Because the respondent says, in terms of 48.6, this decision will be before Parliament, therefore the parliamentary oversight that we insist on. But 48.6 does not mandate or compel the minister to present what we call is in effect a money bill. Because, why do you call it a money bill? Because in terms of 77, anything that you do to increase levy or taxes must be done in terms of a money bill. So what Justice Nuku calls a mere amendment is in essence that what we cannot dispute is that the price of petrol today is this, it will be higher come tomorrow. In essence, is imposed tax in the levy. Let's accept that as a starting premise. Our constitutional contention, which is now this part B, is that you cannot do that outside of the scope of presenting a money bill. Because Section 73 of the Constitution says he must do that. The second issue also raised in the heads of argument is this. In terms of the Money Bills Act, once the minister tables his budget, it must serve before Parliament. Parliament must take it to the Standing Committee on Finance, at which point they will consider the fiscal framework which proposes these increases. That is exactly what is happening now in Parliament. And once the committee takes a decision that we're not happy with this increase, which is a legislative oversight, then they must propose amendments to the minister. Then the minister then decides whether he accepts that proposal or not, but ultimately be voted on by Parliament. Now, our point is this: the minister, with respect, has preempted and bypassed that process and basically nullified the current process happening in Parliament, which specifically has to deal with this specific issue. Last Friday, that committee sat and it took public representations, particularly on this issue of the fuel increase. Submissions were made. The committee is considering those submissions, and then they are mandated to give a report to Parliament. And if they propose changes to the fuel levy, they must give the minister 2 days to deal with that contention. And the idea is the parliamentary oversight will then ensure that he's not taxing without representation. He has bypassed that process. And he's not saying there's an urgent need for it now or any other issue they are dealing with regulation, but to just make good the fact that he did not come right with that. That's what he says. So strictly speaking, as a matter of concept, there's nothing about the fuel itself specifically that requires this adjustment. Is to make good what he didn't get right. Illegally so with the VAT issue. That's the point we're making. And I was saying the problem then becomes twofold, and that's what we say in our heads of argument. One, there is a mandatory Money Bills Act which is underway considering this very issue. It is happening now. That's the process. It makes negatory of that process if the minister is doing what he's done now. That's the same problem we faced in the VAT matter. So if the minister is genuine about this parliamentary oversight that he keeps making reference to, then why does he respect that process? If he's saying, well, this process will come of oversight later on, well, it will come only in October, he tells us, whereas the issue of the consideration of the levy by Parliament is happening now. So which will come first? So if it's authentic about wanting to be held accountable by Parliament, then let that process run, and then Parliament will vote on whether they agree with the fuel increase or not. So the minister now seeks to purport that he's merely exercising his power in terms of 48. Well, with respect, he's not. He's doing it in terms of the budget. It would have been one thing if the minister had made this decision 5 days before the budget or 7 days after the budget. He can't now carve it out of that process. The point I'm making is, if he's doing it in terms of the budget, the Money Bills Act kicks in. And part of that process is for all these committees to review his decisions, vote on it, present it to Parliament, vote on it. That is what is legislatively mandated by the Money Bills Act. So if he's couched it in his speech, the Money Bill says, then that process kicks in. And that process has kicked in, and it says it culminates with the minister presenting a bill before Parliament. That has not happened because the minister has decided he's going to cover just this one aspect and pretend it didn't form part of the budget. The difficulty is this again, Justice Nubu. What he has then effectively done is take a unilateral decision which will continue to stand until he himself as the minister presents a bill in front of Parliament. We are saying 48.6 does not mandate him to present in front of Parliament. And if he chooses not to, then that fuel increase will take effect up until late next year. And then if he decides, given the politics of Parliament and the fact that he doesn't have sway in the numbers, then he just does the process again. That's the point. And we are saying it is not enough for the minister. You can appreciate why he'd say, well, I intend to. Or you can appreciate why he'd say that. He's got that difficulty, but that's not how we interpret statutes and that's how we make determinations of constitutional validity or not. The question becomes, is he given plenary power that's unkept? Of course he is. Of course he is. And that's the difficulty. That's the constitutional challenge we say we're going to present in Part B. To the extent Section 41, and we presume E, is 48(1) sub E. We're assuming that's the provision because that's the catch-all. The minister can do what he wants when he wants, basically, is what it says, which is quite peculiar in itself. Because if you want to delegate power to increase fuel, you can't couch it in such terms. And the case law makes reference to it in heads of argument. It can't be so unfettered. It simply just can't be. And the exception to that is, of course, the Shuttleworth matters, because they were dealing with regulatory exercise of power, not tax imposition. Very, very important. Because that seems to be the basis upon which the defense by the respondent lies. They say, well, the courts have already told us we can do this. Well, if you're reading the judgment glibly, but if you're reading it properly, the court is clear. Paragraphs 70 and 8 and so on talk about we will have a problem if the minister purports to exercise this power for purposes of increasing VAT for revenue purposes. Then you'll have a problem. Those judgments themselves tell you that. They say in this instance, what distinguishes this matter from Shuttleworth and New Africa is this. I'll make an illustration using New Africa, but the idea is the same. In New Africa, consulars and diplomats were sold alcohol and cigarettes custom and tax-free. And the idea was that they use it, whatever it is that they're going to buy tax-free is for their business or their personal consumption. It was, so happens, alcohol in this instance rather than computers. And what they then did is to abuse that power by buying more than they personally need for purpose of reselling at a marked up price given the breaking customs and levy that they enjoyed. The reason the court then agreed with the applicant in that instance was because the argument was, I'm exercising this power to curb a mischief and abuse of our provisions. So what it's being used for is abuse, and they use those words abuse. They then go on and say that is distinguishable, as if foreshadowing this, that is distinguishable when the minister increases levy for purpose of revenue collection and not regulation. In other words, a plenary power to increase that, which is only in the confines in the province of a money bills in terms of Section 77 and 73. And if that were to happen, we wouldn't reach the same conclusion. That is what they say. That's the bedrock upon which we find foundation for application. And you do not have to agree with me now, Justice Nubu. In fact, I've perhaps spent so much time on Part B than I have on Part A. But all I need to convince you of, there is merit to my argument. And I ask you to do no further than have regard to those paragraphs and what they say about this particular conduct. And to the extent you can find the reference that says, if you are increasing VAT for revenue purposes, then you're not protected by our judgment. And if that is good enough for this court, it should then, I respectfully submit, be good enough for us to be allowed to go to Part B. Of course, we can be allowed to go to Part B with or without this court's order, but the danger is this. One, you can't reverse a few payments. You can't. And the degree to which the damage would have been done is neither here nor there. On the minister's own version, this is probably going to be dealt with in October. And in October, whatever happens. But what we have now is an application where pleadings are being exchanged, dealing with the challenge to the VAT Act, and we've undertaken, well, we are party to that in any event, to consolidate that one with this one to definitively answer the question. And we say with respect, there just can never be any doubt to the argument that the minister is exercising plenary power to increase VAT. Pages 7, 6 and 7.
You keep saying that. You're not in the that case.
No, I accept that. Sorry, just let me just explain what I mean by that. There was another matter that preceded this one.
That matter, yeah.
That matter.
Yeah.
That matter deals with the constitutional challenge to the power of the minister in the same way we are challenging it now. So we're saying just consolidate. The point we simply make is within an expedited process rather than one that's indefinite in October as the minister would have it. And the point I was making then, Justice Nuku, is that if, and that's all you really need to look at, and without agreeing with me but see the prospect of success, I'm going to say this for the very last time, I promise, but I think I should because it really matters to me. The sum total of our argument, and I really want the court to capture my submission on this, the entirety of our argument is that there are two types of powers, delegated powers that a minister can exercise. The one is to regulate. The courts accept that if it's regulatory power because it deals day to day with these issues, or even administrators can be delegated, that is permissible under our constitutional order. That I accept. What the courts tell us, it's not even argument formulation, I'm literally citing the Constitutional Court. What it says is that what the minister cannot do or cannot have the power to do is to, in essence, increase VAT and levy for purposes of revenue collection. And we're saying, once the minister says that's what I'm doing, and he says that is what I'm doing at page 7 of his speech, then it must stand to reason that we've got reasonable prospects of success at Part B.
Of course, as my brother pointed out to you, we're not in the VAT case, and we haven't had the privilege of reading those papers. Now, Mr. Hikasibota, do you need us to adjourn? Are you okay?
No, I'm fine, Your Chief. I'm struggling with ventilation. Did you just give me a swab? We're struggling with ventilation. We could just adjourn, Your Chief. It shouldn't be 15 minutes unless we insist on 15.
It's 11 o'clock now. Maybe it's just so that we can make a plan, maybe to open the doors at the back. We're currently working on the air conditioning, so that could be the issue. And that you make yourself comfortable, maybe take your medication as well, so that we try and facilitate to make it more comfortable for you. I have an extra fan in my office, and we're going to ask that my registrar maybe set it up for you, give you a little bit more ventilation. We can plug it in as long as it won't blow your papers away. But I can see you struggling, so let's take a half an hour now.
I appreciate it.
Till 10:30.
11.
11:30, it's almost 11 o'clock. And then if we would just ask, Astrid, check with Jerry, we've got the big one in my office. And then you can set it up next to Hikasiboto that make it comfortable for you. There are plugs available, and we'll bring it from our chambers. Thank you.
I appreciate it.
We'll take a half an hour adjournment.
All right. inputs. Resumption of case number 078807 of 2025.
Very much so. Thank you very much, Justice Erasmus. I appreciate it.
Mr. Kessler, I'm wondering if you can assist the court with something. And then I apologize for disturbing your flow and then just return to it. But do you have access to the Customs and Excise Act? Do you have access to it?
We have hard copies for each one of the copies of the relevant sections.
Yes.
We're indebted.
Just portions.
Thank you.
And
The internet connection in this courtroom is not the best. Thank you, we're indebted.
There's the next one.
so I'm just going to what you stated in the reply, which is that, the one in front of you may not be the right one, which is that the minister's reliance on section 48(1) says is incorrect. In a more updated version of the Act that I have, the fuel levy is defined in the definitions. Mr. Premier, you won't find it in the so and it's defined thus. Let me just go out and check it. So the fuel levy, it is said, means any duty leviable under Part 5 of Schedule 1 on any goods which have been manufactured in or imported into the Republic. Right? And then if we go to section 48(2), just write myself. Section 48, subsection 2 says that the minister may from time to time, by like notice, amend or withdraw, or if so withdrawn, insert Part 2, Part 4, or Part 5 of Schedule 1, whenever he deems it expedient in the public interest to do so, provided that it carries on. My question is it not 48(2) that the minister is in? And is this not the empowering provision in terms of which the minister acted to do what he has done? You could just assist us with that.
Thank you, Justice Mayosi. And that's exactly the problem, which I don't want to go back to in terms of us calibrating our argument as to what we're fighting, but we're here now and we know now what the minister says is his basis. The minister specifically says, I relied on section 48(1). That's what he says. We don't have an answer for 48(2) because that's not the case brought in defense. I've asked my junior to make reference in the answering affidavit where it specifically says 48(1), not 48(2). And it's bundled page 112, where the minister specifically sets out his defense. Paragraph 253. He's correcting himself. What I know for a fact it is there, and it specifically says 48.1.
No, it's not 253.
No, it's not, Justice Mungu. I'll confirm it just now. If I could just make the point. What I know for a fact is that it says 48.1 specifically. That I'm unequivocal about. When we say he has not fully set out his defense, is that he does not tell us of subparagraphs A to E of 48.1 he relies on, because there are 5 instances that he could rely on. He does not tell us which of those it is. We then left to assume that he's dealing, or he's referring to 48.1E, which is the catch-all to do whatever he wants, whenever he wants, basically. So at 009-39, paragraph 220, is where the minister specifically says 48.1. So we kind of met a case of 48.2 if it's not made. Be that as it may, it could well be that he's got power to levy. So our
You
part.
came here to meet the case that you made, that did not make.
It could well be, Justice. But the point is simply that their defense is 48.1. They're saying rely on 48.1, specifically paragraph 220. But just to obviously deal with the contention raised by Justice Mayosi, we're not having a qualm about the minister being able to adjust the fuel levy. That's not our suggestion at all. That's not what you're saying. So, for example, he can do it for purposes of regulating. We accept that. We're not fighting that. We're saying he cannot do what he's doing now. Certainly not under 48.1. That's what we are saying. And that's the case we're trying to meet. And insofar as a fuel levy, that definition is not triggered by what they say.
He limit himself to 48.1 from the paper.
Well, that's what he specifically says.
That's the Gazette notice.
If I could just make reference to it.
RE1, I forgot the case lines page number. RE1.
We'll just find it, I think it's in the answering affidavit, my lady, but we'll just double check
Very
it.
good one attached to your papers, RE1.
Well, what he says is what we complain about yet again. It's at RA101019. It just says 48. And then he tells us where exactly 48 in his answer.
Well, he also says that in the affidavit. He just says 48. Doesn't give a subsection.
It does, 48.1, Your Lordship, at 220.
No, I know that.
And what if as a matter of law, 48.2 in policy, as a matter of law, whatever he says, are we to ignore that?
No, absolutely not. And the answer to that is Harris, which is also now Harris' argument, where it says you can have a post-facto rationalization or justify after a challenge is brought. So that's Harris. So what it seeks to circumvent is precisely what you're concerned the minister might be trying to do, where he realizes, oh, actually, I don't have that power for 8.1, let me rely on 2. He has made an election and it's specific, and that's the case we've been asked to meet. And I'm suggesting that even if, for argument's sake, we could vote for a 2, which I'm suggesting this court should not do because the minister made a deliberate election. If he had said 48, perhaps there's an argument to be made. He deliberately chooses 48.1, and you can't ex post facto rationalize. But the point again is this, the fuel levy definition doesn't come in at 48.1 because it has nothing to do with the fuel levy. If you look at 48, it starts off by saying, in relation to imported goods, there are 4 distilleries in the country, 2 in Durban, 1 in Cape Town, 1 in Johannesburg. That petrol is manufactured locally. So 48.1 does not find application in any event. If you have regard to A to E at 48.1, all those matters deal with how you deal with international merchants and consumers. That's what it does. That's the very basis, because I mean, we know from Indumeni on the canons of interpretation. You must give meaning to the language itself and the context. More importantly, ask yourself, what was the intention of the legislature when they enacted 48? 48 tells you what the intention was, to regulate imported goods. So the increase in levy is not carved out to deal with only imported petrol. It says generally, including petrol manufactured in the country in the 4 distilleries.
So can I interrupt? I'm sorry to do this. I'm just reading your heads. Paragraph 3. The Minister's reliance on Section 48 of the Customs and Excise Act is constitutionally impermissible for 3 independent reasons. First, it says Section 48 does not authorize domestic levy increases, but that can be right, because Section 48 too does exactly that.
And when I was dealing specific 48.1, that's the 41 specifically deals with imported, so he must be out on that basis alone if that's what he's relying on. What now he's getting...
Isn't the difficulty we have here is that, isn't it for the applicant to tell the court that in Part B, this is the challenge that we have now. Because we are now spending more time on this, which is really for Part B. But we are struggling with it because it's not well articulated. It's not articulated firstly in the founding papers. And then in the reply, it seems as if, whether it was in response to the minister's response, the attack is directed not at the provision in terms of which it would appear that the minister acted, which authorizes. So we are just trying to understand what is it that will be the subject of attacking Part B, so that we know, and then we can then evaluate on a prima facie basis the prospects of success, and we leave it there. So we just don't seem to be getting an answer, which we can leave the court knowing that, all right, in Part B, this will be the challenge. I think it's at that light level, not really the intricacies of it.
Thank you, Justice Wu.
So perhaps assist us.
Thank you, Justice Lupo. Perhaps then I could sum up our case as follows. The starting point, even if the minister had said we are relying on 48.2, which he does not, we've got the same challenge that would bring in Part B, which is this. Section 77 of the Constitution says you can only increase fuel levies and taxes through a money bill and a money bill only. There is no money bill. What you have is a notice where the minister purports in terms of 48 to increase the fuel levy for tax collection and to increase revenue, specifically says so. Perhaps let me take you there. This appears in
So in sum, is a submission that the minister is not authorized to act in the manner that he has acted by the way of the notice.
Indeed. And we are saying
because of the overriding provisions of Section 77.
1. 2, because of the decision of Mushaba. It's at 054-32. Those are our heads of argument.
Which paragraphs at Mushaba?
Paragraph 20. This is what it says. The Constitution reserves the taxing power for legislative bodies, and when it permits the imposition of tax, you can read that to include levy.
Of course, that paragraph doesn't read exactly as you quote it to us. It reads differently. Starts with these cases, so it takes you back to casino and so forth, and then why I asked you the paragraphs, because it goes on, and and then it deals with the permanent estate matter quoting, we're going back and Israelson and Heilbeck and Maysboard and Gärtner, and it refers to those cases in the context of how do you determine whether a charge is tax. Remember this matter, Schlager dealt with the conditional authorities in the Popo. And then, particularly from paragraph 35, I think it is, what happened there is then tested against what was said in all those cases, particularly if you're going back to the Sina. You have to look at the context. There's like 5 different tests that you measure it against, but in our particular matter, remember the original act, and that's where, unfortunately, in the rush, the register printed the old original act. But the fuel levy, that definition was inserted in 1987. And the fuel levy goods was then coupled to that, so you won't find it in the hard copy that we gave you. Now, Mr. Katsiboto, speaking for myself, and we don't have to go to the singular paragraph that you referred us to in the affidavit of the minister, but his affidavit is peppered with reference to just 48. Generally. No wonder your heads refer, as my brother Luku took you to it, in paragraphs 2 and 3 of your heads to just 48 and not no subsections. Because he publishes the notice on the 2nd of June, just 48 general. But when the papers were filed, of course, you didn't know what was going to come. So your challenge is why? Now we know. It was done under 48 general. The respondent doesn't have to make a case on the papers. Applicant must make a case. And even as a matter of law, if I may latch on to the question of Mr. Yorsi, where does this take us? If a fuel levy, as set out, and we took us to page 7 of the budget speech. Now remember, the word tax is used, and it seems to me on the following page that was latched. Because he first speaks of a tax proposal. It's about the 3rd line on that page that's attached to your following page. Then he gives the numbers. Then he says fuel levy, uses the words fuel levy, and then he ends off by tax measures. And then he goes to the 2026 budget in his speech. Now, is it what you call it, or what the minister called it, or is it the question of what does it mean in the context also testing against those principles that were set out in the previous cases of the Constitutional Court, to which reference is made in Umhlanga, which is the 2024 decision, the judgment of Tronjay, of which the full court conferred. Gets the point. But that's the context, as I said, speaking for myself.
Indeed, Justice Erasmus. The answer is simply this. As a matter of principle, and what will be argued in Part B, is that any legislative provision that permits the minister to increase the fuel levy is unconstitutional. He could premise his decision on 48.1 48.2, 77, or in different legislation altogether. We know from the Constitutional Court that he may not do so. We'll have regard to the decision of Casino Association, which is also in the Constitutional Court and on point because it spoke about the imposition of taxes. And it says at paragraph 42,
Can you just give me that reference?
the reference is Casino Association of South Africa versus others, and others rather, and member of the Executive Council for Economic Development, Environment, Conservation and Tourism and others. It appears at paragraph 13 of our heads of argument. It says it is well established that influencing behavior is a valid purpose for a regulatory charge. As they did in Shuttleworth and New Africa, if you're seeking to curtail abuse rather than generate revenue, then you can rely on 48.1. That's what the Concord says. It goes further. The gambling levies imposed by Regulation 73.1 are not aimed at or connected to influencing or altering any behavior. Rather, they are revenue-generating charges whose purpose is to raise funds. And for that reason, it was held that that decision was unconstitutional. We're saying the exact same thing here.
And that's the point you make at 3.2 of your head, is that right?
Precisely. That's the sole point to our Part B. Now we're saying we do not have to convince the court that we are right on that score. All we need to do is accept that's what the Constitutional Court said, and at the face of it, there are prospects of success in Part B. Now, to mitigate the damage between tomorrow when the levies increase and whenever this matter is resolved, to give credence and to protect the integrity of Part B should they find in our favor, you must give an interim order. That is the entirety of what we say. So it could well be that 42 says that, and I'm prejudiced here because I haven't had consideration. So I hope the court will indulge me to have a look at 42. But I suspect it is what my Justice Mayos is suggesting, which is he's empowered to in 48.2. But even if he is, our argument still stands. And we're saying he can't now say 48.2 when he had an election and he made the election. That's what Harris says he can't do. Again, the Court is saying he can't do that. But even assuming he is doing that now, our argument stands. The minister on his own terms say, I'm creating revenue by doing this. The court in Casino, the Concord says you can't do that. Either under 48.1 or 48.2 or any legislative provision, because the principle of no taxation without representation requires and mandates the minister to present a money bill. And we're saying 48.6 does not compel him to do that, because that seems to be the refuge that the minister hides behind. By saying, well, there will be parliamentary oversight because 48.6 says Parliament must have a look at it. But they can't if the minister himself doesn't bring it. And if the minister context, I'm not playing politics, context is he doesn't have the numbers in Parliament. That's why he struggled with the VAT issue. So if he then decides, I'm not going to take it to Parliament, there's no penalty for not taking it to Parliament, this will lapse at the end of next year. And rather than face the difficulty of not having numbers in Parliament, I'll let this legislation stand as it is, or my decision stand, and when it lapses at the end of 2026, then he just makes the same decision again. And we're saying our constitutional order does not countenance that for accountability, particularly in taxing the citizens' tax and levy. That's what the Constitution tells us. So it can't be left to the minister to simply unilaterally, by passing or rather giving us a notice that I'm relying on these provisions, therefore levies up. What does it make of the plethora of case law that tells us that he simply can't do that? And we're saying you don't have to buy that argument now. It's enough for you to have reference to what the Concord says. It specifically says in Casino, he can't do that. So there's prospect of success in Part B. That's all we're saying. We're not asking that any power be taken from any minister. We're simply saying there's potential argument here. 41, 42, it's unconstitutional to have that power. And I'm hoping I've captured the point. I'm happy to take further questions.
Are you intending to attack the validity, constitutional validity of those provisions of the Act? Of course, granting that.
And you specifically say that in the heads of argument.
In the heads of argument.
Well, we foreshadowed it in the
RA.
RA.
Evidence. We deal with evidence.
No, we dealt with it in the RA, Justice Erasmus.
At the point of the reply, you are already aware that Government Gazette of 2nd of June, number 52788, 52788, refers to Section 48 generally and the schedules. And of course, in that Government Gazette, you recall that there was an amendment to the proclamation of the 30th in relation to a foreign company. The exemption they brought in. And that's what happened here. Now, clearly there's no attack on the Act itself and the constitutionality. What do we do sitting here as a Part A court?
Well,
there was no, after you received his answer and replied, there was no application to amend the notice of motion and to now foreshadow that Part B will be this. We hear this an argument. And in any event, speaking for myself, the affidavit refers to 48 generally. It's clear from reads 48, we've gone to the definition and you were taken there by my sister Mayosi. And remember this took you to the 1987 amendment where the definitions were now imported into the Act. 48.2, the last amendment thereto was in 1990, it seems, but there was also an amendment by the same Act that amended the definitions. And the minister says in his affidavit, at least for the last 10 years, active in terms of this.
I accept it, Justice Erasmus, and the point we seek to make is this. There are constitutional challenges that are successful before the Constitutional Court on provisions that are excised, forget 7 years, 10,000 years, daily, hourly. There could be a constitutional violation as we speak. That will never ouster the function of a court, which is an authority bestowed with the power to correct precisely that. As a matter of fact, the worse it gets, the greater the urgency to curb it. So with respect, it can't simply be by acquiescence the EFF has cloaked now an unconstitutional provision with constitutionality. What if a party that's just joined Parliament now brings the same application tomorrow? If we're kicked out solely on the basis of we've always been part of this. The simple point is, with respect, that carries no merit legally speaking, certainly not constitutionally speaking. And it could well be that the minister has not relied on 48.2 because it is not doing what he purports to do, if I could read it. The short point I'm making is that he can only decrease the fuel levy in terms of 48.2. He can't increase it. I'll read it again. The minister may from time to time by like notice amend schedule number 1 on the recommendation of the Board of Trade and Industry, we don't know if that was done, or whenever it deems it expedient or relying on that in the public interest by reducing any duty. So you can only reduce in terms of 48.2.
That's not the latest.
He can reduce and increase.
The one that you are reading from, I don't just check.
In terms of the 48.2 we have.
The minister may from time to time, by like notice, amend or withdraw, or if so withdraw, insert part 2, whenever it needs to expedient and so forth. And then, provided that the minister may, whenever he deems it expedient in the public interest to do so, reduce any duty specified in the parts with retrospective effect.
I might be sabotaged.
I thought that council would have looked at the act and the provisions in preparation for the tax.
We would have, Your Lordship, and our contention is that, and I don't want to belabor the point, reliance was placed on 48.1 because 48.1 was made reference to, and was saying even if 48.2 is a refuge to the minister, it is an unconstitutional one.
But the problem with that is that that part has not been pleaded. You look at the answer and the reply to the part, and there is no challenge to section 48 in whatever court. What the reply does to engage with why the opponent thinks that section 48 does not assist, and does not go as further to say that in any event, even if it were so, it is unconstitutional. So this issue now comes in argument. What should we make of it?
No, Justice Nuku. Paragraph 12 says, the minister, we don't know what the minister is relying on. It could be legislative provision, it could be just a notice, it could be speech. We then say we suspect the minister might rely on some legislative provision. If that is the case, we will bring a constitutional review. That's what we say in the founding affidavit.
You get to know about section 48.
Indeed.
But then you're told about section 48, and then the appellate does not take the constitutional point once it now knows that section 48 is the one provision that the minister lies. That's the point that's in.
Thank you, Justice Nuku. So if you have regard to paragraph 17 of the replying affidavit, 17 at 010-9.
Yes. Paragraph 17.
Yes. We then say why reliance on 48 is unconstitutional from para 17.
Yes.
That's the one reference. The other reference is at 010-6. Paragraph 6.
So it's 17 and the other one is?
6 of the RA.
Paragraph 6.
Correct.
Okay.
Then we say section 48.1 deals specifically with imported goods. It provides the minister to impose duties on imported goods. The general levy, however, applies domestically and refined. That's the one aspect we challenge it. The distinction is crucial. Section 48 cannot provide authority for levies on domestic fuel, regardless of its origin, once it enters the country. The minister's misapplication of 48.1 to domestic fuel distribution represents a fundamental misunderstanding of the statutory and confirms the absence of any lawful authority to his conduct. So his reliance on 48.1 shows that he does not appreciate the authority that he has. And so to the extent, one, we say 48.1 does not give him that power as a starting point. Secondly, even if it does, then it's an unconstitutional power. Similarly, 48.2, shooting from the dark here because I haven't read the proper version, even if it permits him to, it's an unconstitutional power. Why? Because Casino in the Concord tells us you cannot increase levies and fuel outside of a money bill. If I could be pardoned for a second to just have regard to 2, and perhaps I can give a comprehensive answer while you have regard to paragraph 6 and 17 of our replying affidavit. And I've read what is hopefully now the proper provision. All it does is you may amend. So we must have regard to the fact that the Act deals with issues other than levies and taxes and increasing monies and decreasing monies. So simply because it says amend or vary does not in itself necessarily mean money. That's not necessarily what it says. And then it has a built-in qualifier that whenever we're talking about reduction, reduction space, okay, that was loud, I hope it transmitted to the bench. He seems to be in agreement. So, did that point land?
Wait and see.
So the point I simply make is this, Justices. The qualification in 48.2 itself says, notwithstanding that he can do all of this, there's an important qualifier that provided when he wants to reduce, he may rely on 48.2. Nothing in it other than say amend, which could be in relation to anything. It does not, however, say you may amend to increase. The only time it talks about changes to pricing is when it says to reduce. So there seems to be an appreciation that even if you were to have that power under 48.2, because of the oversight role, no taxation without representation, will specifically say if you want to make any adjustment unilaterally, that can only be when you reduce. That's how I read 48.2. So the short answer is 48.1, it relates to imported goods. The minister says 48.1, he's out just on that basis. But even if he's not out on that basis, he's out because the courts have told us he can't increase revenue using this, this process. 48.2, again, it's out because of the qualifier at the end. You can only reduce unilaterally. But even if that's not what it provides for, but it in fact provides for, you can increase levies, it's unconstitutional for the same reason 48.1 is unconstitutional, in that it allows the minister unilaterally to increase without any parliamentary process. And the only time there could be a potential check on that decision is if the minister himself presents it to Parliament. So Parliament does not have authority to download the notice and deal with it. The minister must present it in front of Parliament. And we can all accept that it must be a money bill that it does is through, because it's only through a money bill that you can increase levies in terms of 77. And we're saying to the extent the minister has not done that, neither does he claim that he consulted and is required to with recommendation. All you know is he made that decision. And I hope that rounds off that aspect, but I'm of course happy to address any further questions that may come from the bench.
So I have a question. So if you go to paragraph 65 of the Parliament these lines, so in that paragraph, you say something to the effect that the minister's decision to increase the fuel levy is not on its own unlawful. You see that in that second sentence?
Indeed, my lady.
Yeah? But what you take issue is the fact that he made it come into effect on the 4th of June. Is that right?
One. That's the one aspect.
That's what you say here in this paragraph 65. So if this court is not with you and this court finds that the minister acted lawfully or was empowered to make it come into effect on the 4th of June, does your complaint then fall away?
The Part B complaint.
What does that then do to your... You say that you don't necessarily quibble with his authority to increase the fuel levy per se. It is that he did it, he made it come into effect on the 4th of June that you quibble with, because then he excludes the parliamentary process by doing that. So if this court is of the view that the minister was lawfully empowered to make it come into effect on the 4th of June, what does that do to your complaint, given that you don't quibble with the decision itself without the 4th of June?
Let me put it this way, and if I'm not answering my ladyship's question, then please bear with me and try again. As a matter of principle, how you increase taxes and levies as a matter of principle is through a parliamentary process. The minister himself cannot do it. What is done is trigger that process, which requires parliamentary oversight before it can be of any force or effect. we're saying he has bypassed that parliamentary process and given effect to his own decision without parliamentary oversight. That's the constitutional difficulty we have and the legality difficulty we have. So when we say we don't quibble with the fact that he's got that power, we mean it in that narrow sense of the word or of the expression. Not that he can decide and that's the end of it as is done now. Now we're saying what that means for our Part B is this. If we're dismissed here, all the dangers we speak about in the interdict sections kick in immediately and are not reversible and they're quite grave. That's the difficulty. What we're asking this court to do is find in our favor. Why? On the balance of convenience, it must do so in the face of what we're dealing with here, which is to suspend the levy. And the reason we say that is the minister is not hard-pressed to do the levy issue. He's saying, I'm doing it to counter the political effect of not being allowed to increase VAT. He says that it's that basis upon which he couches his decision. We're saying, well, then if he didn't see fit to increase the levy 2 weeks ago before the VAT issue, why does he say it now? He tells us, I'm trying to make good the political mess I created. That's what he says. So saying in those circumstances, it is only prudent, and of course we can only appeal to the court. It's not mandatory that you grant us that order. We're just saying, given the prospectus of what is at peril and the balance of convenience, that order must be given, and then we can always fail in Part B if it comes to that, and I'm hoping I've answered the question. The decision cannot simply be issuing a notice and immediately kicks in. If he had pended it post, say for example, the parliamentary process which is looking into the very issue, or pended it following Part B, we would have no problems whatsoever.
So, your Part A review, you want it pending final resolution of, final determination of Part B, right? Which really, just loosely speaking, it's indefinite. Why don't you make your Part A review pending the conclusion of the parliamentary process?
I'll take instructions standing here. I have no difficulties with that.
If you say that it's already underway, the standing committee is doing this, it's doing that, and so on and so on.
I can always take instructions, Justice, on that point, but the point I'm making is, yes, so under prayer 2, at page 2, we do say pending Part B. But equally, if we lose here, the minister himself says we might deal with it in October. So in equal measure, that is indefinite itself. And for the minister, it gets worse. He actually does not even have to trigger the parliamentary process. And I hope I've captured that point properly, because he's saying what negates our concern is 48.6, which says Parliament will have oversight. But nothing about 48.6 says he must do it. And there is no punishment for him in failing to do so. And I'm saying, outside of politics, just pure contextually, we can see why you have difficulties doing that in Parliament. For that reason, you may choose then to not take Parliament because it's not required to. And come the end of 2026, he can just do the process again, and nothing stops him from doing that. So it's that perpetuity, it's that concern that we're very much concerned about. And we're saying, ultimately, whichever you cut it, I accept that it won't come, a resolution won't come in the next month, it won't come in the month after. But if he were to follow the process, I'm happy, I really am happy to amend our notice of motion to say the alternative, whichever comes first. It could well be late. No, it could well be. It could well be. But the point still remains that there is a balance that the court has to strike here. If at the face of it, and I repeat the point, I don't have to convince you about the merits on a balance of probabilities and on Plasco and Evans. But what I'm simply saying is, if you have regard to the court and they say one thing and one thing only, this cannot be done, that gives you an indication of how strong our prospects of success are. And that's the sole consideration in deciding to give the interdict or not. I've yet to come across case law that says, well, but the problem is we must solve this in November. I've always understood it to be with just taking a glance without questioning the granular detail of what does that mean in practice, when and how. That's the function of Part B with respect. So if I can convince you that you're entitled to interim relief and just glancing at what might come at Part B, regardless of the merits, the consequences, what it means for the fiscus. And because the minister is now saying, well, there's that jeopardy that we'll lose on revenue, but it's caused by the very fact that he exercises power unlawfully to begin with. He wouldn't have been here if he had followed the process. So there's no revenue being lost as a result of the application. And I've hopefully addressed Justice Mayusi.
Another question from Justice.
Yeah, I don't know now, reading that paragraph to me suggests that the applicant accepts that the delegation of that power to the minister is proper and lawful, but it is how he exercised it that is offensive. Is that the case?
It's not our case, Justice.
Oh. Because when we say the minister took the impunity decision on the 21st of May 2025, this in itself does not render the minister's decision to increase the fuel levy unlawful. What should we make of it?
If he's doing it in a regulated constitutional manner, and that process is not taking the decision, announcing the proposal at the speech, issue a notice. A notice does nothing more than notify. So it is an instrument, notice. Does not add any...
Doesn't that mean that the applicant accepts that there is empowering provision which authorizes the minister to amend the levy subject to whatever processes and without giving effect to the increase prior to those processes? Is that not how that paragraph should be read?
Justice Muku, the minister has got power to adjust the levies. For example, to regulate behavior. As a principle, he can have that right. With the carve-out.
Just explain to me the paragraph.
The carve-out. And for that reason, he can. That's the point. He can. In this instance, he can initiate any bill. It's his function. No one else can. Section 73 says only the minister may introduce a bill to increase fuel levy. He can do that, and we accept that as a principle. He can make the announcement. We accept that as a principle. But that's not where it starts and stops. I.e., my apologies to the court.
So, people can't edit themselves unless
So you say that the way we should read that paragraph is to mean that his role is to introduce the bill that will result in the increase, and then the parliamentary process must take its course. By putting it into operation prior to that process, that is what it offends.
And it's not even me who's saying that, it's the Constitutional Court and the Constitution itself. So all the minister could have done up until this point is through tabling a motion, through tabling his speech in Parliament, which he has done,
You could have said yes, Mr. Gaswat, because I'm trying to understand that, so I was giving to you how you
Justice
understood your explanation.
Yes, Justice Nuko. So they can't be kicking in now outside of that and outside the bill.
But I have another difficulty.
Indeed, Justice.
You see, we are dealing here with the applicants being a political party represented in Parliament. You don't have to go to the papers to find that. It's not and as the Minister points out, have been party to previous adjustments. It was 7 up, 1 down. Really, they must know this is done in terms of that legislative framework set on customs and excise. So that's where the fuel levy is defined. And publication in those previous years would have taken place in terms of Section 48. Now, in argument only, not on the papers, Section 77 of the Constitution. But no attack on the empowering provision of the Customs and Excise Act, Section 48. Now, how do I deal with that having regard to the portion of the Constitutional Court in Mazibuko? And where there is non-compliance, then you can levy it. And even in the CID case, where they perform functions of the local authority, and it only applied to those property owners within the CID. Still said no problem.
Indeed, Justice Erasmus. As we understand the subsidiary point as argued by the respondent, the minister, is that you deal in the review and setting aside with PAJA and the underlying legislation, and you attack that. Before any reliance is placed on the alternative, you can attack it on legality. We're saying this is not a review application.
Maybe you misunderstood. I'm saying in the context of the players here in this case, I would have expected that full frontal attack in the founding way.
And our answer, Justice Erasmus, is Part B analysis does not require the level of depth, certainly that I've been advancing before this court. It's to suggest what it is we're going to deal with there. And that's a proper question, but in answering it now, the minister, and I'll deal with the question of they've always been in Parliament. The minister, as a matter of fact, not laying any blame, for the first time in his answer, tells us he's relying on 48. I'll deal with the EFF having been there all this time. But factually, for the first time, he says in his answer, this is my defense. That's why I said, okay, there's the founding affidavit for purpose of our reply, which is then answer. Having said that, 010-6, there's a full frontal attack on 48.1. So we foreshadowed it. We foreshadowed it at 12 of the founding affidavit. We preempted that the minister might actually do this. The minister does this, and then at 010-6, we then deal with 48.1 specifically. And I would respectfully submit, not much more is required in terms of substance in this court for purpose of fully setting out the attack on 48. We merely need to foreshadow. And we're saying that's exactly what we've done from paragraph 6. The heading is section 48.1 is inapplicable to domestic levies. Excuse me. So there's a specific challenge to 48. Foreshadowing, not full argument, full fleshing out of facts, because that's a Part B problem. We then say this is in any event a legal argument, not a dispute of fact. We then go to heads of argument and we lay out sentence by sentence the constitutional challenges that beset 48.1. And we're saying in equal measure now 48.2 as well. So as we understand it with respect, it's enough for an applicant to foreshadow Part B, not argue Part B. They foreshadowed it in paragraph 12 of founding affidavit. In the replying affidavit from paragraph 6, they actually have a heading dedicated specifically to 48, foreshadowing, not fully arguing the matter. And then we do more in the heads of argument where we actually actively argue the matter. And we place no less than 5 case laws that say exactly what we're saying now. So, I mean, of course, it could well be that the court takes a different view to it, but our answer to it is simply that we're just foreshadowing. And there's no requirement that you would deal with the Part B issue to granular detail. That's what Part B will be there for. I have not taken instructions on this thing has happened for the past 7 times, why now? But we can accept that the EFF is not one being that is indivisible. Different people occupy that office at different times.
He's answering, and it's not dealt with.
Well, it could well be.
So the applicants knew he was going to say this.
But
But you see, it's also important because in that whole inquiry on factors to determine whether it's a tax or not, and that's not the closed number, historical conduct is important. But it is, it's a fact.
no, I can accept that, Justice Erasmus, and I'm saying if it's a factor, it's an insignificant one. The question that has to be answered is whether the minister has got constitutional power to do what is done. That's the question that must be answered. That question can surely not be pegged on how many times has the EFF been involved in such a process. Ultimately, the analysis is a legal one, taking into account the constitutional framework. And in answering that question, this is a constitutional framework. These are the powers that are bestowed on the minister. This is what he has done, is in compliance. To the extent the fact that the EFF has been part of it, I don't know if that's a costs issue, I don't know if that warrants a footnote in the judgment, I do not know to what degree it should matter. But ultimately, it surely can't be one where a decision of whether to interdict such an important decision should turn on the fact that the EFF has been in Parliament for so long, having different personalities representing it, having different lawyers representing it, and who would know what informed the decision this time around.
Also your colleague.
So with respect, Justice Erasmus, even if I were to accept that that is a factor, it surely is one that can't play a meaningful role in the decision making, especially on a matter of this nature. I'm loath to ask if there are any further questions, because then I tend to not move on. Yes, Justice Marius. I've got one. Thank you very much. Thank you, Justice Marius. So in short, we foreshadowed at FA12, we foreshadowed or responded at para 6, and then went to town in legal argument, because ultimately this is still not a question that turns on facts, because those seem to be common cause, but it turns on a legal question. And I don't think there can be any criticism that we've not fully set out the constitutional attack on the conduct of the minister. One, failure to comply with the Money Bills Act by bypassing the process that considers this very issue, which is yet to be determined. And secondly, whether 48.1 or 48.2, which is we say you can't now after the fact rely on, but even if it is, the courts are clear that you can only adjust levies, and I suppose in part answering Justice Nku's question, only when you are regulating behavior may you adjust. And that's what happened in Shuttleworth and in New Africa and many other cases. But what you cannot do in terms of constitutional framework is to increase levies, which are set out in Section 77, a legal argument, not a factual one. You cannot do so without presenting a money bill. I don't have to convince you that I'm correct. All I need to show you is that that seems to be the position of the Constitutional Court. And if that's the case, then the balance of the requirements for an interim interdict I must satisfy, most of which as intimated to. Unless there are further questions on Part B, I'm happy to argue the balance of the requirements for an interim relief.
I thought the question yourself against asking.
No, it wasn't just Justice Smith. I'm here to assist you.
They've also raised the non-joined DMRE, etc. You can generally just deal with.
No, just generally it's without merit, Justice Erasmus. and then the answer is this. Section 6, Rule 612 itself provides that if any party is not before court an order is made, they can come for some sort of variation. Because what they complain about is not so much the interest of the ministry, energy ministry. It's more of, well, they have to implement this decision, so they would have had to be here. Then it's just a question of giving them the order. They do not say this is what they lose out on. They say because they have to undertake these processes, implement, they should have been here. Well, so does Total Energies. They have to implement the decision. They're not cited. There's no qualm about that. So is the rest of the populace. They have to adjust their budgets, and therefore they have to implement the decision. They're not cited. There's no qualm about that. What distinguishes that ministry? So, two answers in short. One, the rules appreciate that there can be oversight, and I'm not admitting that there is any, but assuming there was, they accept in urgent matters, things like this tend to happen. They've got recourse in terms of the rules if that ministry so pleases. And secondly, if the nub of the complaint is that they have to implement and they would have known if they were in court, then you just give them an order. Dealing with the question of, I don't know if you want me to go to Rule 30, but I'm happy to, in short.
You can deal with any client necessary.
As a quick piece.
I said at the outset, we're not going to, let's get to the point. Not going to go on sideshows. So if Mr. Taylor can convince us there's something in it, we might ask you.
We withdraw the notice.
Good. There we go.
And I suppose that's the same with the urgency issue, because I was going to say it's 3 court days that's really in dispute here, but if that point is not persisted with, I'm happy to sit down as well.
Yeah, no, you made the point as to, and we know the timelines that was available between 21 May and midnight tonight. The facts are what they are.
As the court please, and I take it that I don't have to address you on the balance of the interim relief. I haven't dealt with the prima facie right and alternative remedy, but it's there in the founding affidavit, it's there in the head, it's there in the, and we will place reliance in it.
There's no need.
As the court pleases. I'm indebted to the court.
So it's 12:36. I discussed with my colleagues this morning that we, and these things have changed, that we get some food. So let me just check with this and see what we're. Do you need to take a break at this stage? Or having some sustenance and maybe take medication?
What we could do, he's saying, what we could do, I'm happy if the court is so minded. I'll just indicate when I need to step out, unless of course there's an insistence that
So
they want to take a break. I should be fine, I'll just indicate when I
Then
need
you
to
can
step
just
out.
indicate to us, maybe swap around with your colleague.
Well, I'm not sure I'm going to do that because he's arguing I need to reply. No,
Yeah.
and I'll just
But
take on
if
the
you need
station
to
here.
step out, just indicate, we'll take an adjournment.
As a court, please.
I hope the fans are assisting.
They are. Thank you very much,
Maybe
Justice
let's go back
Erasmus.
to my changes vote.
Thank you very much.
Thank you.
Justice Erasmus, members of the court, I've noticed that despite the 1 hour 30-minute limitation, the debate's gone on for 2 hours and 5 minutes. May I just say I hope I'm not that long?
No, that was the bench.
Yes, I hope I'm not that long. I'm going to choose my words very carefully in this matter, not only because I represent the EFF on occasion and I don't want to prejudice my future work stream, but also because what the criticism that I'm going to make against my learned friends as the legal representatives of the EFF is that they've evidenced absolutely no litigation discipline in this matter at all. And you need to bear that at the back of your mind in circumstances where they are asking you to stop a state department from giving effect to its lawful constitutional powers, which as we stand here continue to be lawful and continue to have effect. Because what did our learned friend's client say in paragraph 12 of the founding affidavit, which took up a lot of debate and whether it foreshadowed something or didn't foreshadow something? At 001-11 para 12, this is what the deponent says. What is, however, clear is that the minister has not followed the legal process in imposing the levy, and neither can he at this stage. And then they move on to the correspondence. So just as a matter of wording and pleading, let's take a step back and analyze that statement. I'm not going to rest all of my propositions on the use of the definite article D as opposed to the indefinite article A. But the point is that the deponent tells you that there's this legal process, the legal process, and the minister hasn't complied with it. It means that the deponent, on advice, foreshadows that there's a breach of some kind. And the debate that took up most of the morning today with my learned friend is as a result of the fact that he couldn't pin down his case and what it actually was. When it suited him, he argued for administrative action. When it suited him, it was then a legality review. When it suited him, it was then a constitutional challenge. And why it's important for us to bear in mind that litigation discipline in cases like these are important is because what does the Constitutional Court say in outer at paragraph 71? It says, before granting interdictory relief pending a review court, in the absence of mala fides, not pleaded by them, fraud, not pleaded by them, or corruption, not pleaded by them, examine carefully whether its order will trespass upon the terrain of another arm of government in a manner inconsistent with the separation of powers. That would ordinarily be so if, as in the present case, the state functionary is restrained from exercising statutory or constitutionally authorized power. That's where we are here.
Well, you can take that one step further with the reference to order.
Yes.
The type of matter would be because the court caution.
Correct.
Where you're dealing with fiscal matters.
Correct.
That is necessary to give effect.
Correct.
To the budget.
Correct. And
you shouldn't just look at broad,
correct.
Unconstitutional claims.
Correct.
And we must stay in our lane.
Correct.
Unless.
Well, listen to what.
And those are just
listen to what the Constitutional Court says. In that event, a court should caution itself not to stall the exercise unless a compelling case has been made out for a temporary interdict. And where's that compelling case made in motion proceedings? In the founding affidavit. And in the founding affidavit, they explicitly tell you, we have this generic constitutional complaint, we identify that there's a breach of the legal process, but actually we don't know what to say about it, just give us our interim interdict anyway. And look at what the court concludes by saying. This is so because in the ordinary course, valid law must be given effect to or implemented except where the resultant harm and balance of convenience warrants otherwise. And I'll deal with that a little bit later. So that's very important to set the scene of what we're dealing with here. And what we're also dealing with here, with all due respect, is an instance where the interdict sought by our learned friend on behalf of his client is actually pointless. And the reason it's pointless is for the non-joinder point. And my learned friend very flippantly says, oh, Total needs to be joined and Cecil and whomever else. But what his client didn't say in the replying affidavit is that the joinder doesn't matter. So all of those arguments are raised new for the first time from the bar. But let's leave aside technicalities, let's go to the merit. The fact of the matter is that the Minister of Finance tells you all I do is I set the fuel levy. The Minister of DMRE is the one who translates that under the Petroleum Act into the petrol price. Even if our learned friends have made a good case against us, which they haven't with all due respect, the impact of that gazette going out today means that the DMRE, sitting wherever it's sitting, can already start the process to initiate their powers
under 2.1c. And what was my learned friend's harm that he identified? His exact phrase was, petrol prices are going up. And the non-joinder point is fatal to him because it's not the Minister of Finance who determines the petrol prices, it's the Minister from the DMRE. And even if at this late hour they could somehow join the DMRE into these proceedings, they also have an odocral problem. Because the Minister of DMRE's exercise of his lawful power under 2.1c of the Petroleum Act is lawful until it's reviewed and set aside. And that argument applies as against the DMRE, it also applies as against my client. And so that's why actually this flippant response is no good, because if they want to stop the petrol price, they have to go after the right person. And let's just take a step back and analyze what the consequences are for them for proceeding in the absence of the Minister of DMRE. If it's not about the actual petrol price, which we know is done by someone else, it's only about the minister's function, then their harm is not about the petrol price. Their harm is a pure rule of law harm. And if you accept that that's then what their identified harm is, ask yourself the question, where does the urgency arise on a pure rule of harm question that will not remedy the harm that they say they identify, which is the petrol price going up? So they can't run away from it in the way they've attempted to do so. And that's very important because that's as we stand here. That's what the representative on behalf of the government of the Republic tells you is happening. And all they say to that, in fact, is nothing. And that's quite frankly detrimental to their case.
I don't understand this non-joiner point.
Yes, Justice Nuko.
The civil right, whatever DMRE does,
Yes.
flows from what the first respondent.
Yes,
does.
correct.
So, if the levy stays, then they do what they must do. If it is suspended, then that's what does it?
No, it doesn't follow with all due respect, and odocral's the answer to that. Because let's just work out what happens. Say we know that the Gazette has already gone out. So we know that the minister has signed the levy, it's going to be implemented, assuming this court doesn't stop it from being implemented. By midnight tonight, yes. At 100 hours and 1 minute tomorrow, these prices will increase and change. Let's just accept that as the starting premise. But how it gets there is through the DMRE. Now, to answer your direct question, Justice Nuku, it's twofold. Firstly, the suspension order that they seek, and maybe we should go to the notice of motion so we can just remind ourselves of what it is that they actually seek. They say in their notice of motion at prayer 3, it's suspending the decision by the first respondent to increase the General Fuel Levy by 16 cents. So that's a self-contained prayer. But what they don't deal with is the ramifications of that decision after it has been taken. And as we stand here today, the DMRE is going to respond to that. They might have even responded to it already because they need lead time before the petrol price increases. And under odocral tells you, even if you suspend, that when the DMRE relies on that to trigger a separate power, that even if it's based on an unlawful act, it continues to have lawful effect until that unlawful act which triggers the exercise of the separate power is reviewed and set aside, and we're not in that territory. So the non-joinder is fatal to them because not only does it demonstrate that they don't go after the right person that they say has caused the harm that they're objecting to, it also evidences with all due respect that this whole exercise of theirs in getting an urgent interdict now is an exercise in futility.
But the way I understand, Mr. Bennett, the way I understand the affidavit of the minister and the structure is that grade 2, that's my decision. That's the decision I made.
Yes, correct. Correct.
I announce, and it's not petrol price increase, it's fuel.
Absolutely.
Because it covers both petrol.
Absolutely.
The 16 and the 15 cents respectively. But your grade 3 implementing that decision. That's the job of the team.
Yes, correct.
So the non-joiner is more to do with prayer 3 in the notice of motion. Because the Minister of Finance says, I make the decision, I publish.
Yes, but
The implementing agents.
yes, but and look at the problem in the prayer. Look at the problem in the prayer.
It's interdicting
The first respondent.
the first respondent
Yes,
from giving effect.
yes. But it's not interdicting the operation of that decision. It's interdicting the first respondents from giving effect, not everybody else who might rely on that decision. And so even if my non-joinder point is not fatal for them in the strict sense of non-joinder, it creates the practicality problem of the harm that they have to confront.
I'm not going to base my brother with you and take it back to his question. Because if the decision of the first respondent is set aside or suspended, it's of no moment, because then the implementing agency can't implement because the court has suspended that decision.
No, with all due respect, that's only as against the Minister of Finance. It's not as against the separate administrative act identified in Paja and identified in Odecral in respect of the DMRE. But I think you've got my point. Thank you. And so you heard me earlier about the threshold that they have to meet, and it has to be about the clearest of cases. But let's just engage with what my learned friend engaged with the bench around Section 48. And in response to a question...
Now let me tell you this.
Yes.
I pointed out to Mr. Kassiboto that the affidavit of the Minister
Yes.
refers generally to Section 48.
Yes.
There are 3 instances that I could find where he refers to subsection.
Yes.
So in paragraph 238 and 309 he refers to paragraph 48, section 48 sub 6.
Yes. That's the parliamentary override mechanism, yes.
121, 125, 140, 143, 146, 224, 159, 332. All of those refer to 48 general.
Yes, correct.
There's only one reference
To 48.1.
48.1, and that's in paragraph 220.
Yes. On 009-339. Yes.
So I asked Mr.
Yes.
I didn't give him all the paragraph.
I've got them. I don't know if it will help.
Does that, is it the same as mine?
Oh, it's the answering affidavit uploaded on case lines.
No. I just listed
Yes,
the
yes.
paragraph numbers.
I've got 23. So 23 is a general reference. 121.2 is a general reference. 125 is a general reference.
You don't have to repeat it unless you disagree with
Oh,
what I've read.
I can't remember your entire list, but I take the point.
So it's only in that one paragraph,
Yes,
and it doesn't say in that paragraph
yes,
that it's only the 48.1 that's applicable.
yes. I accept that. Then can I just say from the point that my learned friend was engaging with Justice Mayosi about 48.2, if that distinction, which is introduced in the replying affidavit, has any magic, the logic of the minister's answer given in 48.1 applies with equal force to 48.2, because as Justice Erasmus, I think, pointed out, that in the content of RA1, the schedules, both of those sections are cited in respect of the different amendments. And so the point to be made about this is that there's no magic in this attempt to say that the minister pleaded improperly and therefore it's an irrationality in the sense that he applied the wrong section. You have to remember that at the time that the answering affidavit was drawn, they themselves hadn't identified anything as to the substance of their challenge beyond an incorrect reading of Section 77 of the Constitution and the monies, I'm going to call it the Money Bill Act. And so the minister gives you the fullest answer that he can, but to the extent...
Simply what he says,
Yes.
in terms of the customs and excise tax, it makes provision for the adjustment of Fuel Levy.
Yes.
And that is done in section 48.
Yes.
There's the process.
Yes.
And that's right.
Yes.
And the law permitted me to do it.
Absolutely.
And people begin tonight unless the court orders me out.
That's right, and I accept that. But your lordship in the debate with my learned friend pointed out the Mazibuko frontal challenge and subsidiarity problem he has standing in his way. Because remember, in order to get that interdict, assuming they're in the territory of a constitutional challenge, because we still haven't worked out what their Part B is. Because remember, their Part B relief, as it's currently pleaded, just says reviewing the minister's decision. It says not one word about a constitutional challenge. But let's be generous to them and assume that they can say that. Then what they would have to do is they'd have to show the degree of the constitutional breach for the thing that empowered the decision. And the thing that empowered the decision is Section 48. And there's no pleaded case about Section 48 because in violation of the principle of subsidiarity and with absolute ignorance for their frontal challenge problem, they rely directly on the Constitution. And what you will remember in the My Vote Counts litigation, the first My Vote Counts judgment, when there was a direct attack in the context of the right of access to information, Justice Cameron, if I'm not mistaken, who penned that judgment together for the majority of the court, said that might all be fine and well, and you might have identified a serious constitutional problem here. But the difficulty for you is you've got the PIRE Act standing in your way, and you can't come here immediately and claim breach of the Constitution. You have to go according to, there's a method in which you reach us. You go through the so-called statutory chain before you can rely directly on the Constitution. And may I make a related point to that? Because what's actually happening here is they're developing, with all due respect, an argument to undo not only Section 48 of the Constitution, but to undo the Constitutional Court's own authority in New Africa, where it endorses this exact mechanism, this exact act, as a competent fiscal measure within the overall basket of measures that the Minister of Finance on behalf of the Executive can trigger. So never mind their frontal challenge problem, they also have a precedent problem, a stare decisis problem. They can't just wish away New Africa. What we know from Camps Bay paragraph 28 is that stare decisis applies, both horizontally, both vertically at least, the higher court binding the lower court, and the own court, its own judgments in future. And they don't even come anywhere close telling you that New Africa meets the threshold of the exceptionality to overturn that judgment so that you can depart from New Africa. You're bound by it. So with all due respect, it's not helpful to them for them to even rely on these constitutional principles, because the more they push at it, the bigger their problems become here. And let's just say that the Part B court is going to be with them on everything, which it might do. The difficulty for us sitting here in Part A, in terms of what the Concord told you in para 71 of Outer, is that it can only grant a temporary interdict in the clearest of cases. And all of these serious defects evidencing no litigation discipline is not just procedural point scoring. It speaks to fundamentally what interdict power this court can exercise and measured against what standard. Because look at what the Constitutional Court says at Outer, at paragraph 26. It says, I was going to tell you what it says. A court must also be alive to and carefully consider whether the temporary restraining order would unduly trespass upon the sole terrain of other branches of government even before the final determination of the review grounds. And then it goes on to say, a court must be astute not to stop dead the exercise of executive or legislative power, and my learned friend's laptop has decided to freeze, so I can't continue reading the quotation, but I think you get a flavor of where I'm going with that submission. Because you also remember that the Constitutional Court tells you that you're not allowed a pre-enactment challenge as well. Admittedly, in different circumstances in Glenister 1, at para 44 of that judgment, where it was talking about a preemptive strike to the bill at the time, and I know we're not in the same territory, but just think about the logic. The Constitutional Court says that you can't allow a pre-enactment challenge because that would put the court into the place of the legislature, not only determining the outcome, whether the bill or the instrument, which is provisional, should become final or not become final. You also entangle the court in the exclusive competence of other organs of state, and this court is not adequately equipped to do that. Because the Constitutional Court went on to say in para 26 of Outer, this approach accords well with the comity the courts owe to other branches of government, provided they act lawfully. Yet another important consideration, and this is why Part B, and talking about Part B is so important. Yet another important consideration is whether in deciding an appeal against an interim order, the appellate court would in effect usurp the role of the review court. Ordinarily, the appellate court should avoid anticipating the outcome of the review, except perhaps where the review has no prospect of success whatsoever. So in other words, when the Con Court sat as an appeal court in the e-tolls matter, it was alive to the fact it was an appeal court, and it was alive to the fact that it can't render the review moot. But because it says that it could have done so in instances where the review bore no prospects of success, by logic, it tells you that when the applicant starts a quo and launches its application, it has to demonstrate prospects of success, not to any threshold. And my learned friend just suggested, I just have to show you that we have prospects. I just have to show you that there's an arguable case here. It's higher than that. Because para 71 of that same judgment, it's okay? Para 71 of that same judgment tells you that it has to be in the clearest of cases. So with all due respect to our learned friend, that argument about, you know, Part B doesn't matter, actually it does matter. Can I just address this? Because also in defense of the litigation ill discipline, a throwaway comment was made, oh, we'll amend, or we can amend our Part B notice of motion. Let's just take a step back and understand how that works. If you look at their notice of motion, what do they cite? They cite Rule 53. Rule 53 has an inbuilt amendment clause. Yes, I accept that. But that's only after the receipt of what? The record. So they can't amend now using Rule 53 amendment rules because they haven't got the record. And also remember, the record is relevant to administrative action challenges, not legality challenges, because legality tests rationality of the measure chosen and the ends it achieves, and certainly not a constitutional challenge, because a constitutional challenge can be conducted in inverted commas in the abstract, because you don't have to evidence the harm, you can demonstrate the harm purely having regard to the Constitution itself. So this amendment that they talk about is not there for them. And if they then chose, and I think one of the learned justices on the bench said, well, you could have amended your notice of motion. They'd have to do so, as far as I'm aware, under Rule 28. But that would concede that their relief is bad. It would concede that the very thing that they argue in front of you allegedly in the replying affidavit and the heads of argument, the so-called constitutional challenge, is not there in the first place. And they can't turn it around and say, my client didn't plead correctly. Let's remember who they are in the proceedings. They're the applicant.
I thought you would have said, okay, bring your application, file your notice, I'll take my 10 days, then I'll reject, and then you take 2 months, you argue the lead time, the pumps are running.
I mean, we could have, but, you know, they must have their day in court. They tend to like that, as far as I remember. But the point is that if they exercise the so-called right of amendment, they concede the fundamental defect which they try to remedy in the replying affidavit and the heads of argument. And you don't need me to rehearse for you what Titty's Bars says about making out a case in reply. So, with all due respect, that argument about, oh, we'll amend, makes their situation even worse. Because then how does the Part A court even know what it's evaluating against? Some abstract notion of a constitutional challenge where the grounds aren't even foreshadowed in the papers, and you must then decide whether or not that's the clearest of cases. With all due respect, if that's the position they're in, we don't even have to go into the merits of OUTA, because on their own structuring of their notice of motion and their founding affidavit, their case falls down. And the fact that he said, with all due respect, we'll amend, concedes that. And let's just remember this, because I don't want to be unfair to my learned friends. What does Bartow Star say at paragraph 28? Bartow Star at paragraph 28 says, and it says the following, no, that's not the part of that I want. If the court will bear with me. Yeah. No, I apologize, it's not 28, but in Bartow Star, it might be 26, just look. In Bartow Star, what the Constitutional Court says, here we are, it is 26. In these circumstances, it is clear that Paja is of application to this case, and this case cannot be decided without reference to it. To the extent, therefore, that neither the High Court nor the SCA considered the claims made by the applicant in the context of Paja, they erred. Although the applicant did not directly rely on the provisions of Paja in its notice of motion or founding affidavit, it has in its further written argument identified the provisions of Paja upon which it now relies. So the relevance of that to this case is as follows. Firstly, we're not in that world. We're not where they're claiming the right under Paja and they put out the facta probanda to support the legal conclusion. They're in the world where it's sort of paint by numbers, or pick as you go, because as the difficulties arise, the case then morphs. So we're not in the exact Bartow Star world that I was talking about in a moment. But in any event, to the extent that the criticism is leveled at my client, oh, you didn't plead with specificity 48.1 and 48.2, the engagement that Justice Erasmus and I fall squarely within that engagement is that you don't have to identify it with that degree of precision. You can set it out in its general terms. And then it's competent when it's set out in its general terms to address it in legal argument. But what they do is they flip that completely on its head. It's absent in the affidavits. There's no facta probanda. And then my learned friend even accepts it. They address it in the reply and the heads of argument. And the reason that and I know that this is an important case and that there are important principles at stake, and in my learned friend's world, devastating harm that's going to unfold on the country. But this is an important thing because of what this court is being asked to do. And when the court considers constitutionality and rights and all those sorts of things, it also has to bear in mind what the courts have told lower courts, if I can use that old-fashioned phrase, about being careful to be tempted by applicants who don't come with a proper case, who claim improperly direct breach of the Constitution, who claim improperly that you must give them the most far-reaching remedy, that it goes right into the heart of the executive in terms of its revenue-raising proposals, and stop them from doing that in the absence of the challenge, and in the absence of the court confirming that it's unlawful. That's why that matters. And so it's not only a question of form, it's a question of substance. And so our learned friends can't run away from that with all due respect, and the consequences for that, for them, is that it's game over. And I've mentioned Plascon Evans earlier. I'm not going to go back to Plascon Evans, but let's just deal with this. Because my learned friend kept on saying that the history of the EFF and its participation in the parliamentary processes don't matter, that doesn't oust the court's constitutional jurisdiction. That may be correct for the purposes of Part B court, but for the purposes of this Part A court, you have to consider whether or not the case has been made correctly. And let's just analyze two things about the case on urgency, and I'm not going to argue urgency fully, I just want to highlight this to the extent it's relevant that they get over the urgency hurdle for you to even entertain them on the merits in the first place. Let's understand this from a judgment in the Labour Appeal Court, if I'm not mistaken, HCI versus Golding, whilst my learned friend's computer fixes itself, at paragraph 24, what that the court said there is that in an urgent matter, oh, here we are. Thank you, I'm indebted to my learned friend. As Prest points out, a matter which is inherently urgent may be rendered not urgent and fall outside the provisions of the High Court rules where an applicant delays in bringing the application as one of urgency. A delay of 9 days may not appear to be lengthy, but given the deploringly slow pace at which the wheels of justice turn, but in circumstances where the applicant knew when the disciplinary hearing was to commence and yet gave the respondents less than 1 day before this application was heard to file its answering papers, having taken 9 days to draft its own lengthy founding papers. I agree with Mr. Pretorius that urgency is self-created. We're not exactly on those facts, but we're almost exactly on those facts. And so the court must be very slow to let my learned friends get over the urgency hurdle, considering the relief that they seek on the merits. And in fact, it might actually be kinder to them to strike them for urgency and not go into the merits, because if you go into the merits, you're going to have to give a judgment, and you might say something which forecloses on a future cause of action of theirs. Absolutely. But yes, of course. But no. Well, you'll have to think about that. You'll have to think about it. Yes, and the appealability of that order is something that will unfold.
Because if we don't, what's going to happen?
Sure, I accept.
And that's the difficult thing that I reversed with Mr. Cassidy. It's not always fair to the court that we have to deal with matters on this basis. But I realized that the letters went off on the 26th, between the 26th and today, and a lot of things happened.
All I'm saying, and of course urgency is discretionary, all I'm saying is considering the relief that they seek, just be careful. Because remember what operates alongside urgency and delay, Barnett, please. What operates alongside urgency and delay is the ongoing harm principle that comes from Minister of Barnett versus Minister of Land Affairs in the Supreme Court of Appeal. Because what Barnett says to you is that where the wrong is ongoing, and in their world the wrong is ongoing, the consequences of the minister's decision have all these knock-on effects, and if the petrol is not stopped at the pump today, that financial harm which will continue, that's the ongoing harm in their world. What Barnett says is that in that situation, you are entitled to approach the court at any stage in order to try and vindicate your relief. So the point is that the delay is relevant for the urgency, obviously, but they mustn't act, with all due respect, as if they don't have a remedy in future, because they do have a remedy in future. They can come back on similar facts and seek similar relief. But they're not entitled to that here. If I may move on. I want to spend a little bit of time with the debate that happened with my learned friend on the difference between a regulatory charge versus a tax. Could we start with the Mohlaba authority, which they commended with some force to the court as demonstrating the correctness of their points? Let's just remember what Mohlaba was about. Mohlaba was about traditional authorities and whether or not they have the power to tax. And in paragraph 20 of that judgment, that's what the Constitutional Court confirmed. It said, the Constitution reserves the taxing power for legislative bodies, and that when it permits the imposition of tax, it does so expressly and regulates how the power must be exercised. Legislative bodies can delegate the power to regulate, but not the power to tax. So that first paragraph, you see my learned friends are making some noises of agreement that apparently this supports them. But the reason it doesn't support them is that their arguments only find purchase in these proceedings if you accept their attempt to undo the distinction that exists in law, that a levy under the Customs and Excise Act is not a tax, as confirmed in the Constitutional Court in New Africa.
But isn't context everything? The way when one looks at the case.
I'm not sure what that means.
Because when you look at New Africa, those are the people in the exit lounge or entry lounge.
Yes.
With a duty.
Yes.
The court in Moshlaba went on the historical path
Yes.
of the charges being levied against individuals in the rural area.
Yes.
Including that you need a proof of address to get your social security.
Yes.
You need to pay.
Yes.
And in the one instance, the reference is made in the judgment, the purpose for which these funds are raised.
Yes.
For the public good.
Yes.
Or what is it raised for? Remember the new car that was bought from my chief?
Yes.
In the judgment of
Yes.
And then the court goes and I'm taking Mr. Gaston and gives the background for all these other cases for similar.
Yes. Yes.
So this is how it is.
Yes. And but their general proposition, with all due respect, I'm sorry, I don't know if I finished.
So you can accept, Mr. Clement, that we've looked at this matter, this case, because we've circulated amongst ourselves.
Moshlaba?
Yes.
Okay.
We
Can I
circulated amongst ourselves
Can I,
yesterday.
may I just make my life easier than having regard to that? Please, when you consider the Moshlaba judgment, also look at paragraphs 21 and 23, because that, with respect, is dispositive of our learned friend's case. And in addition to 21 and 23, and on your way to landing at 35, which is the paragraph that that the judge presiding indicated that he had regard to, also look at 26 and 27. And very importantly in 27...
Well, in 21, with reference to Shuttleworth
Exactly.
and Casino,
Exactly.
the court says, and keep New Africa in the back of your mind,
I will.
it's permissible
Yes.
to delegate certain tax
Correct.
powers
Correct.
to the executive.
And
And that's customs and excise.
yes, exactly correct. Exactly correct. And 27 is where they start that analysis. So I'm with you. Because what I say is that in Moshlaba, there was a general taxing power under Section 25 of that instrument, which gave the Premier in those circumstances a power to tax. And then the tribal authorities, and whether or not they could do so as well. But that was a tax in its proper sense. Whereas what they do in those paragraphs, particularly the citation of Shuttleworth, is that they accept that there's a distinction in our law between taxes and regulatory charges. And what you'll remember from Shuttleworth, which is also endorsed by the Constitutional Court in New Africa, is that regulatory charges bring in money, so they might raise revenue. But that doesn't make it a tax. And just because a tax also raises revenue, the two are not the same thing. And so when we look at things like history and context and all of those kinds of considerations, the court will consider the fact that this act has been in place since 1964. And that the architecture of the act, even though subject to some amendment over time, has not fundamentally been changed or taken out some of those customs powers on the basis that they're taxing powers. In fact, the most direct case that we've had with that recently is New Africa. And New Africa, the Concord endorses by, I think, a split of 9-2. This architecture, which I'm saying to the court, demonstrates that what the Minister of Finance does is not a tax and doesn't have to go through the Section 77 process and so on. May I, whilst I'm on my learned friends' authorities, because I apologize.
Said to you that one has to look at the context, because you will recall that in Shuttleworth, the court explains why they stay away from precisely.
Exactly.
And that takes us back to page 7 of the minister's speech.
Yes.
He used the word tax twice, but in the context of tax evasion.
Yes. Yes. I'm going to address that shortly, because I think because our learned friends, with all due respect, don't read the Money Bills Act correctly, and I'm going to show you why. And what the Minister says in his budget speech actually fits perfectly with what the Money Bills Act provides. And it's not, as they say, that all of the things that are spoken about in the budget and then in the money bill itself has to be a tax, and I accept that. And I'm going to come there if I may. But before I go there, I just want to commend a few more paragraphs in the Casino Association judgment to the court, because our learned friend, again, put significant emphasis on this judgment. Can I just remind the court of two things? The first one is that in paragraphs 4 and 5 of that judgment, you will see what the regulation under challenge purported to do. And the regulation under challenge purported to set taxable revenue at certain amounts, and then as an automatic tax would apply to that subpopulation in terms of what they would have to pay under that particular regime. But at paragraph 14 of that judgment, and you'll remember that in this particular case, Constitutional Court confirmed the High Court's act the High Court's finding of invalidity. It set out there in paragraph 14 the essential rationale that the NEC may not introduce a provincial tax. So the Casino Association case, with all due respect, doesn't get anywhere near our learned friends' facts that they have to confront here, because here we're dealing with a national power that's explicitly catered for in an act that competently, because of New Africa, delegates that power to the minister. So the attempt to read some other instrument and a judgment about some other instrument to give meaning to the Customs Act is, quite frankly, not sustainable when you have the most direct judgment in New Africa telling you the exact opposite. So let's then go to the argument proper about Section 77 and money bills, and then the Money Bills Act and what needs to happen and not happen. If you'll give me a moment. The first one is, let's just look at the wording. A bill is a measure to be introduced in future. It has no legislative effect when it is in bill form. This is Section 77 of the Constitution, the bullet point of their argument. What the minister does is the minister adjusts something which currently exists, and he does it through a regulatory power, not through a substantive power of amendment. So the attempt to latch onto Section 77 and force all regulatory powers that have a revenue impact into Section 77 doesn't get out of the starting blocks, because the wording of the Constitution is against them. That's the first point. And I'm not going to rehearse all of those other arguments about subsidiarity and frontal and all of that. You know what I say about that. Just look at what is their lodestar. Their lodestar is Section 77. But Section 77, with all due respect, is dead against them. That's the first point. The second point is, let's look at the...
Sorry, and why do you say it's dead against them?
Let's go to Section 77, if we may. Section 77 of the Constitution says, a bill is a money bill, not a government gazette notice. So that's the preamble to Section 77 sub 1. I don't know if I have to go any further.
I think the difference between you and them is that what I understood the applicant is saying is that the issue of the fuel levy is the one that cannot be delegated because it amounts to imposition of tax. And you don't agree with that?
No, I don't.
Why do you say it's not imposition of tax?
Let's go to let's go to New Africa, paragraph 110. This is a judgment of the constitutional. No, New Africa. I'll go to Shuttleworth just now.
Yes.
Look at what it says. It says, when one gleans from the long title, what one gleans from the long title is that the Customs Act mandate is to, inter alia, control the importation and use of certain goods. Now just stop there. That's the analysis of the preamble. What do we have in section 48.1 and section 48.2? 48.1, they tell us helpfully, applies to imports. Justice Mayosi raised the fact that 48.2 deals with domestic. And so to the extent that that's the fuel duty, the Constitutional Court is telling you that that conduct by the minister falls exactly within the statutory intent of the Customs Act. Let's read on. In this matter, the minister highlighted that the primary reason for the amendments was to curb abuse by diplomats. This in turn informs us that the charge is in fact regulatory in nature. And then it goes on to conclude that it does not violate section 77 of the Constitution. So we say we're in that territory. But let's look at that even more, having regard to paragraph 105 of that same judgment in New Africa.
But in the argument then that the difference between the imposition of fuel levy and those charges in New Africa, that those were regulatory which are permissible. But here, because the levy is of general application.
No, with all due respect, it's not a general application, and that's the distinction with the tax. Income tax, or VAT, applies unilaterally the moment you engage virtually anywhere in the world outside. Here, you have to have a car, or a vehicle, and you have to go to the petrol pump, and you have to consume the petrol. If your harm is indirect because that cost is passed on by retailers or passed on by logistics companies or transporters or whatever the case might be, that may all be well and good, but that's not an argument against the minister's power still being a regulatory charge in the way that New Africa describes.
As I understand, it's in New Africa it was set to be a regulatory charge because it had something to do with curbing abuse.
Yes, but that diplomats.
But here, what is it regulating? How do you call it regulating?
Let's just read paragraph 105 together of New Africa, and I'm reading on the paginated page 47, 4 lines from the bottom. In determining whether a charge is a tax, one has to find the dominant purpose of the legislation. Now remember what the Customs Act tells you, what the dominant purpose of the legislation is. It's to regulate prices of certain goods, right? And then it says, this was set out by this court in Shuttleworth. Moseneke held that the use of the word fees, tariffs, levies, duties, charges, or surcharges are not determinative of whether the statute in question imposes a regulatory charge or a tax. It was held that the seminal test is whether the primary or dominant purpose of a statute,
And in this instance, the customs.
There you go. Yeah, absolutely.
If the Constitutional Court in another matter says the dominant purpose of the customs
Correct.
excise duty is to regulate,
That's it.
what goes.
And if their argument is that the exercise here is for some ulterior purpose, they must make that case. They don't mention ulterior purpose anywhere in their founding affidavit. If they want to argue that it's the 48.1 and 2 provisions that we're talking about are somehow inconsistent with the remainder of the Customs and Excise Act because of this so-called plenary power given to the minister, they must bring the frontal challenge. So, it's fine for them to put the hypothetical propositions about, in general, oh, this levy is against everybody and it's bad and people are going to pay
But
more.
that's not how you look at
Absolutely
it. You
not.
look at the empowering statute.
Absolutely.
What is it that-
Absolutely.
All right.
And look at what the court went on to say there. It says it was the court's decision, and this is the New Africa court referring to the Shuttleworth court. The court's decision that if regulation is the primary purpose of the revenue raised under the statute, so the Constitutional Court also tells you that if it's a regulatory measure, it can raise revenue. And it goes on to say it would be considered a fee or a charge rather than a tax. So they can't hook all their submissions on the fact that just because the fuel levy increase is going to be increased and it raises revenue for the government in terms of the budget, that makes it a tax. The Constitutional Court told you that that kind of thing is entirely permissible. The opposite is also true. If the dominant purpose is to raise revenue, then the charge would ordinarily be a tax. The court has also emphasized that there are no bright lines between the two. Of course, all regulatory charges raise revenue. Similarly, every tax is in some measure regulatory. That explains the need to carefully consider the dominant purpose of a statute imposing a fee. And lastly, at paragraph 109 of that judgment, the court...
Paragraph 107 was the one that was quoted in the club.
Oh.
Well, 107 of New Africa is quoted in the club.
Oh, I thought Mohlaba preceded New Africa. Was it not the Shuttleworth? So was New Africa. It must have come up very closely.
If you look at...
I apologize. It doesn't matter, with all due respect, Justice Erasmus. The point is that this attack is rebutted by the Constitutional Court itself.
Yeah, that... it's quoted in the...
Do we need to find it? Okay. I'm indebted. I'm indebted. I mean, not to criticize my learned friends, my heads were just as late, I think, as theirs were, but I was trying to bone up on Mohlaba very quickly this morning, so I haven't considered it very carefully.
It's quoted paragraph 27.
I'm indebted.
107 found its way as a quote in paragraph 27 of Mohlaba.
Yes. Well, I'm indebted. And lastly, in 109, now, because remember, Justice Mutu, this is still relevant to the question you asked me about how do you determine all of these things. This is what the Constitutional Court says about the very statute they complain about. In its long title, the Customs Act states to provide for levying of customs and excise duties and a surcharge, for a fuel levy, for a road accident fund levy, for an air passenger tax, an environmental levy, and a health promotion levy, the prohibition and control of importation, export, manufacture, or use of certain goods, and for matters incidental thereto. So the very Act tells you that the architecture that they complain about is the thing that the Act permits. And just let's take a step back, because my learned friend said, you know, old statutes are set aside and old statutes are found to be unconstitutional. That's fair. But let's look at what Parliament itself has done as an expression of legislative intent. In the last 10 years when the EFF was in Parliament, Parliament didn't want to amend the Act to take away these 48 powers. Parliament didn't want to rescind the Act to take away these 48 powers. Parliament tells you we're quite comfortable with the Minister exercising this because the Act creates the kind of fiscal regime where expertise is needed and where efficiency is needed. And this was quoted in New Africa. It was also dealt with in Shuttleworth. And that's why the Minister of Finance is appropriate to be that person who makes those decisions. And whilst we're talking about Shuttleworth, let's go there together. My learned junior will find it for us. The particular paragraphs I want the court to look at in Shuttleworth is 48. Which was about the charge and the dominant purpose of the statute.
Must give him your laptop because this seems to be loud.
Yeah, and it's also an Apple product, which I'm not particularly partial to, but that being the case. So 48 is dominant purpose. Scroll on to 53. And then look at what the court says in the Shuttleworth context, but think about how it applies here. Because at paragraph 53, what the court does is it does the historical analysis, Justice Erasmus. It says that in that case, the exchange control legislation was specifically enacted to stop capital flight from the country. And then it talks about the historical origins, about the Great Depression and why it was necessary and all those kinds of things, which is not really necessary for us to go on to here. 54. Whilst that Updates? Well, I think you get my point. There's a coherence between Shuttleworth and a coherence between New Africa, and we're not in that world. So when you look at Shuttleworth, in addition to 48 and 53, look at 54 and 57, because that's the full answer to the EFF's case here. So that's on the substance. Let's just talk about the procedure, if we may. Oh, my learned friend has it now. No, I don't need to read it out. You'll just have a look at it when you're considering 54 and 57. But let's go now to the Money Bills Act, because our learned friends also place a lot of emphasis on the Money Bills Act and how that relates to the fiscal framework and the minister's obligations and when he must engage the parliamentary process and all these kinds of things. Let's do some basic statutory interpretation and start with Section 7, Sub 2, Para D. Or maybe let's read the preamble. The minister must table the national annual budget in the National Assembly as set out in Section 27 of the Public Finance Management Act at the same time as the Division of Revenue Bill and the Appropriation Bill. And then you go to 2 and it says, in addition to the information stipulated in Section 27, the documentation tabled by the minister with the national annual budget must include, and then go down to sub D, tax and other revenue proposals, including the contribution of the different revenue categories to national revenue for the next 3 financial years. So in other words, this act, which they placed a lot of emphasis on, actually is undermined by the wording of the statute itself, because it says to you that there are other forms of proposals that take the form of other revenue proposals that also have a contribution to different revenue categories to national revenue for the next 3 years. So this objection that our learned friends have, that this is, a secret tax, and because it plays the function of a tax in the sense that it increases revenue, it must be a tax, is undermined by the very act upon which they say that Section 48 is in conflict with. It doesn't help them. And what makes it worse? Let's go to Section 8.6 of that same act. Section 8.6, talking about the minister's report and the information and the amendment, indeed, that the Parliament can engage in. It says, if the report includes amendments to the fiscal framework or revenue proposals. So in other words, the very act that they rely on accepts the structure, accepts the constitutional structure that the Customs and Excise Act fits into, and foreshadows that it will be treated differently to tax, and that it will constitute other revenue proposals. So to the extent they say that this whole thing is an exercise that is outside Section 77 and it's in breach of this act, they're wrong, because that very architecture creates an exception from a traditional money bill, which is about tax, as opposed to other revenue proposals, which is where we are and what the Constitutional Court has told us about in New Africa and Shuttleworth. And let's just remember what our learned friend also said during the course of the debate this morning. What he also said is that he said at different stages there will be votes, and that Parliament can, must vote down the fiscal framework, or Parliament must vote down this specific measure. All I'd say is that if Parliament and the EFF in Parliament can achieve that outcome by using the GNU arithmetic, because remember, my learned friend also said that the minister was using this as a means to bypass the GNU arithmetic. If Parliament actually has that much power, then that's their alternative remedy. They can go and whip the votes and command a majority of 201 and stop the minister dead in his tracks. And that's actually what the Money Bills Act tells you is the potentially correct outcome. Not a court in an interim interdict usurping Parliament's role and usurping the executive's role by diving headlong in breach of the separation of powers. That's the difficulty for them that they can't run away from. And let's just look at what the Constitutional Court said, because remember, when those legal challenges are put in their way, with all due respect, it then becomes about, oh, but it's so bad, and oh, the people are going to suffer, and it's anti-poor, and it's all those kinds of things, and it's impractical. How are you ever going to recover this money from the government? Firstly, that's no basis of a cause of action. But secondly, if my learned friend's computer fixes itself, the answer is given in paragraph 54 of outer. Because what the Constitutional Court said there, in the context of e-tolls, and you'll remember the argument made by outer in the e-tolls matter is that this financial harm is going to be so terrible, you're never going to be able to recover your money, it might take forever to be able to do so. The Constitutional Court said this: the court rejected as not persuasive enough the submission that should the review be successful, SANRAL will be obliged to refund the millions of agreed...
reading from the case?
Yes, outer.
From the summary.
And I'm reading from the case, outer.
But that's a reference to another case.
No, I think it's talking about the lower court. When it's referencing court here, it's talking about the Prinsloo High Court, not another court or another case. Because remember, they were sitting as the appeal court and the direct appeal there. So the court, and now just listen, it's, with all due respect, it's the court rejected as not persuasive enough the submission that should the review be successful, SANRAL will be obliged to refund the millions of aggrieved motorists the toll charges. So let's just adopt that to our situation. You can read it as saying, this court should reject as not being persuasive enough the submission that if the review is successful, that's their review, the minister or the National Treasury or the DMRE or SARS or whomever will in law be obliged to refund those people, and practicality is not enough because Justice Mosaneki, on behalf of the majority, said it is questionable why the harm motorists are likely to face is irreparable. Should the decision to impose toll on the roads be set aside by a court, I know no reason why affected motorists would not have an enrichment claim to recover toll so paid to SANRAL, or why the National Executive Government or SANRAL would validly resist repaying the toll charges. So in a practically difficult situation where financial harm was going to be done and there was a question about refunds, the Constitutional Court said that's not the job of this court sitting as the interdict court. That's not enough of a cognizable harm. They've got remedies available to them. Let them go and do that. And I'm sure there would be many lawyers who practice in the area of class actions who would be licking their lips at the prospect of being able to sue the court on an unjust enrichment claim for an unlawfully imposed fuel duty. But the Constitutional Court said that for your purposes, with all due respect, as the interdict court, it's not your concern and you shouldn't be so bothered by that. So that's what I have to say in response to my learned friend from the morning and what he presented in front of you and where, with respect, the difficulties are in their case. Could I only take the court from my learned friend's heads? I'm just going to pick up on 2 points, please. The first one appears at internal page 15 of their heads. My learned junior will get the case lines reference in a minute. But internal page 15, under the heading, Separation of Powers Harm. Separation of power arguments. The case line's reference is 054-41. Look at what our learned friends say at paragraph 43. The ministers claim that courts should show deference in fiscal matters cannot override express constitutional prohibitions. Well, they're not in that world because they haven't been able to show an express constitutional prohibition. And then they make the generic claim that constitutional supremacy under Section 2 means that no government action, however fiscally convenient, can transgress constitutional limits. However, that's directly contradicted by a 2008 case in the Supreme Court of Appeal called Paper Manufacturers. And in similar facts, the court said in the context of an argument that a charge there had to be considered as a money bill, the court said there in direct response that that's not correct. In fact, the court said that in matters like these, where it requires some degree of fiscal expertise, and I'm just going to try the paragraph if you'll bear with me. The court said in that case that this was perfectly permissible because the nature of these charges are important. My letter junior will look for the reference. I'll come back to it if I can. So I just want to say that that broad argument is not correct because paper manufacturers is the answer, coupled with the other arguments that arise from Shuttleworth, which came after paper manufacturers, and in respect of New Africa, which came out most recently from the Constitutional Court. Can we just also go to internal page 22 of their heads of argument, so that's 7 pages on. In the middle of the page it says prospects of success in part B, and where it says prospects of success in part B, they start addressing all these constitutional arguments. And all I want to just point out to the court is that they do so with some degree of fluency, and they do so with some degree of rigor. But the stark thing about that is that fluency and rigor was missing in the founding affidavit. And it's quite frankly not good enough for our learned friends to just turn around and say, well, you know, we didn't know the case to make, but in response to your answering affidavit, then we did know the case to make. And I just want to point out there that that illustrates they could have run all of these arguments and they didn't. Justice Erasmus presiding, we've obviously submitted heads of argument, but the way in which I've structured my submissions this morning, or this afternoon now, I think, I'm not going to go back to those heads. I think I've integrated all of that argument. I was going to say, unless there are any questions, I'm happy to take any questions.
I understand one or two questions dealing with context.
Yes.
Now, indicated earlier on, my understanding was reading the founding papers.
Yes.
What occurred here was that I think it was Friday when the founding papers became available.
Okay.
And then there was a lull.
Yes.
So all we had was the notice of motion,
Yes.
the founding affidavit, and the annexes.
Yes.
So one had to try and understand what the case is about.
Yes.
You don't have an answering affidavit, you don't have reply.
Yes.
So my reading, mainly the minister's budget speech was important.
Yes.
To understand the purpose of the fuel levy being increased.
Yes.
And the context within which it is done.
Yes.
So remember, it starts off with the VAT debacle. On page 6 it deals with the VAT debacle, bottom of the page, and then says it's a difficult environment, and actions need to be taken to increase revenue.
Yes.
For a specific purpose, and that was to protect and bolster frontline services,
Yes.
while expanding infrastructure investment,
Yes.
driving economic activity. Now let me start there. Under that section now could
Yes.
be a tax, or could an inference reform means a tax?
No, and the reason it can't be is because even if the minister uses language which may suggest that, it's not.
But then he hasn't used the word tax yet.
Yes, but the point I'm making is that it's the source of the minister's powers that constrain what he can or cannot do. And if here, what the minister does is ultimately then sign RA1, which is under the Customs and Excise Act, then he's exercising what we would say is a lawful power for a legitimate purpose. If, and if I can...
Just pause.
Yes.
The next line in his speech is important, or might be important.
Yes.
Understanding what's going on.
Yes, yes.
Because he then says, to this end, and I'm quoting from his speech,
Yes.
this budget proposes an inflation-linked increase to the General Fuel Levy. And one of the parties quoted that.
Yes. Because I don't know if the speech is binding.
No. But remember, context is everything.
Yes, I agree.
So what does this mean? It's an existing levy that was stagnant for a period of 3 years. He says,
That's a policy choice, yes.
we're doing an inflation link.
Yes, that's right, he does say that. And in his answering affidavit, he says it restores the real value of the levy.
Now you've already answered, because that's policy decision.
Yes, absolutely. And
by implementing the policy decision we've argued earlier, it takes an executive action.
correct. Which is then
I just wanted to understand.
which you can review then, legality under Motau in the Constitutional Court. But remember what the Constitutional Court says in Motau is that you don't even go into the reasonableness grounds, you only limit yourself to rationality. And the test for rationality is, does the means meet a legitimate outcome? And so...
And then of course the general proposition as we discussed there.
Yes, absolutely.
Those look at the labels.
Yes, yes, absolutely. And can I just say one last thing on this particular point though? And I said that it was paper manufacturers earlier. It's not paper manufacturers. It's actually Shuttleworth at paragraph 126. And this is talking about policy decisions, because you'll know from the reasonableness, you'll know from that old Bartow Starr case at paragraph 48, where Justice O'Regan is quoting Justice Scott's JA as he was in the Supreme Court of Appeal. And she effectively says that, you know, courts must be careful to substitute their thinking with the thinking of the actual experts, and that they must be slow in those situations, except, and as the Constitutional Court foreshadows in Outer, in clear instances where it would be unreasonable or would be irrational.
You've referred us to that paragraph.
Yes. Yes, absolutely I have, because that's the deference clause. That's where, that's a strong proposition of why courts should show deference in these types of cases. And in I'm indebted to Justice Erasmus. And in Shuttleworth, at paragraph 126, in the context of, because the court in Shuttleworth was also considering regulatory charges and, you know, is it a tax or not a tax, and if the minister has this regulatory power, is it good or bad or whatever, and I'll conclude on this point. When they were quoting Darwood, and remember Darwood is the classic vagueness challenge type of case. When quoting Darwood, they said the following. They said, a further situation may arise where the decision maker is possessed of expertise relevant to the decisions to be made. And when you read that side by side with Bartow Starr, we add that into the pot as a separate reason under the rubric of the separation of powers as to why this court should be very slow to enter into that terrain. So it was paragraph 126 quoting Darwood, which you read side by side with an understanding of deference from Bartow Starr. And that tells you that you should be very careful to go near these types of things, particularly when you're sitting as an urgent court. May I take an instruction? Those are my submissions. I'm indebted to the court for its time in sitting through lunch.
Mr. Kasipota, we ready to sit through by this
I'm happy to continue if everyone's comfortable with that.
Thank you. Been a long day. And I know that council.
I'm desperately trying to not lose this matter on a simple issue of my point didn't come across. It turns out it's more contentious than I thought it would be. The EFF submissions are simple ones. The question before this court is an interim relief that is being sought. That is all the court must answer. It must answer whether there are prima facie rights. The EFF lists those rights in its affidavit. There doesn't seem to be any serious challenge to those prima facie rights, even if open to some doubt. It is therefore enough for me to simply submit that the populace will be unlawfully charged a petrol levy. It is enough for me to say there's a general public whose representatives are acting unlawfully, and as a result there's a pecuniary loss. A prima facie right, even if open to some doubt. I don't think there was a serious challenge to that assertion. If anything, at page 001-36, the minister himself says,
Oh, that's on the speech.
yes, where he says that there will be a negative impact on the populace and it will hit their pockets. This is page 7 of his where it says access to safe, reliable and affordable commuter services is critical for local earners who spend more than 50% of their income on transport. 50% of their income on transport. The minister tells you that is what at stake here. The second question this court has to answer is whether there will be appreciable harm if the minister's decision is not suspended. What the minister is talking about there will happen as of 1 second past midnight tonight. There can't be a serious dispute around that. Once this 50% now added to that fuel, you add 15 cents for petrol, for diesel, 16 cents for petrol, that will continue up until there's a resolution. That money can never be claimed back by the citizens, including the marginalized ones that the minister himself is talking about. I don't think there can be a dispute in that respect. What perhaps the matter rests on is the question of the balance of convenience, which has consumed the entirety of my debate on Part B. The relevance of the entire Part B debate speaks to just that one aspect of what the court actually has to decide. And in so deciding, I must not satisfy this court that the EFF will win at Part B. All you have to ask is there this peril? Is it impending? Is it reversible? And if the answers are in favor of the EFF in that analysis, well, what do we counterweigh that with in favor of the minister, the balancing exercise? What that would certainly mean is that certainly the minister in his official position stands to lose nothing other than his powers being temporarily suspended in light of the peril that will materialize. I have suggested that the minister has not suggested any pressing reason for this decision other than to raise revenue. He says, I am raising revenue. This is an important exercise because in Shuttleworth, and I'm having paragraph 110, maybe we'll just make reference to it and you can have New Africa, sorry, paragraph 110, New Africa, paragraph 60 and 61 of Shuttleworth. This is the crucial aspect of the debate. And it seems to me quite apparent, frankly. What those courts say, you can increase levy as a minister, which was my response to Justice Nubu, provided you are regulating behavior. Correct? Shuttleworth was about regulating behavior, money flow. And then he says, because the underlying intention to the decision is to regulate behavior and to stop abuse, I will accept that unilateral adjustment.
Of course, the minister and the then DG Kariaku is now the last time I checked, the governor of the Reserve Bank. They were placed to point out, no, it's not raising revenue, although I think they collected 190 billion or something, 190 billion. And we're not, it's really regulated. The court made that point that they were trying to stress that, please, get us away from collecting revenue.
And you can appreciate why they were so stressed to do so. Because there's got a legal implication, not just for purpose of the minister, but the constitutional order of the state. Now, inadvertently or otherwise, my learned friend submits that regulation in that context means regulation of prices. Not at all. Regulating behavior, that's what the judgment tells us. Now, regulating behavior...
I understood the submission to be that in order to determine whether a charge will be regarded as a levy or a tax, you have to have regard to the dominant purpose of the statute.
And I have no difficulty with that proposition, and I agree with it. But the point here is, it's not even a question of a dominant factor. It is the only factor that is raising revenue. That's what he tells you. He's not saying I'm concerned about money flows. He's not saying there's a concern about this fuel issue, people are buying it illegal, and I'm regulating that unlawful behavior. He's saying I am raising revenue. So there's only one factor.
Looking at the wrong place for the dominant purpose, because it must be located in the statute that gives the minister the power to levy that charge. Is my understanding correct?
I read it slightly differently, Justice Nubu. How I understand it, and certainly how the courts have undertaken that exercise, is to ask themselves, what is the decision maker saying is his decision? What does it say is the reason for that decision? And what impact does that decision have? Does it have an end result of raising revenue, being the dominant factor? Or is it more concerned with what they're concerned about in Shuttleworth, which is money flows?
Give us those authorities so that we can read them and compare them to the ones that Mr. Clement referred us.
Perhaps let me give you this flavor then, Justice Nubu. Sorry, I didn't want to read to court. So those references are of course dealing with this, but I'll read you 110. Okay? This is New Africa. From 110. Yeah. Paragraph 110. You can keep Shuttleworth open to Justice. I'll also refer you there. But I'll start with New Africa.
Okay, I will find it.
This is what the court says in paragraph 110 on this analysis. What one gleans from the long title of the Customs Act, or was accused of relying on a case that has nothing to do with the minister, but the principle was the same. Now I'm on point on all fours. What one gleans from the long title is that the Customs Act mandate is to, inter alia, control the importation and use of certain goods. In this matter, the minister highlighted that the primary reason, so in other words, the minister said, so that was a factor, and we're saying the minister said here as well.
In this matter, the minister highlighted that the primary reason for the amendments was to curb abuse by diplomats. This in turn informs us that the charge is in fact regulatory in nature. I conclude that the minister is amending the schedules did not violate 77 of the Constitution. I now consider whether the minister's decision was rationally connected. So the point is this: 77 binds at all times unless you are regulating behavior. That's the point we're making, that you cannot increase tax or fuel levy without parliamentary oversight, taxation by representation, except in policy considerations where you can't be asked to go to parliament when monies are flowing out. You can't be running to parliament when the diplomats are abusing their liquor and cigarette customs breaks and rebates. It's in that exceptional instance that the minister then can do what he did, which is why it was condoned in Shuttleworth. Similarly, New Africa. That is worlds apart from the minister saying, the only reason I am making this amendment is to generate revenue. Now, let's just think about it for a moment. If in those instances the minister is not required to comply with Section 77, i.e. through a money bill, when will he ever be required to? In instances where he doesn't qualify or give further reasons, he simply says, I'm raising revenue. So if the minister does that and is not required to comply with Section 77, when will he ever be required to? Let's pause for a second. This is Shuttleworth, paragraph 60. There the court says, I've already found that the exit charge did not have revenue raising as its primary object. In other words, this is the instance that will permit the minister to act as it does. It was directed at capping or discouraging export of capital. I am not persuaded by the submission that the wider import would likely be preferred in the instance of the ordinary meaning of calculated. And then it goes on. Section 9(4) of the Act is directing and allowing Parliament to scrutinize fiscal measures that are planned or designed to gather income for the fiscus. The court says specifically, if the design of the legislation is to collect fiscus, then there must be this parliamentary oversight. Distinguishable from a Shuttleworth case, whose primary function is not to increase fiscus, but to regulate behavior. That is just a simple point we're trying to put across. I don't have to convince this court that I'm good on submission. All I need to do in dealing with 25% aspect of what I actually need to do with this court, I then introduce Part B. And in fact, I would humbly submit we do a little more than raise a doubt about it. I think we've sufficiently made the point for purposes of Part A. Paragraph 61. It is true that during the subsistence, the tax charge generated revenue of approximately 2.9 billion. In my view, that garnering of income by Treasury was incidental to the dominant object of regulating and discouraging capital flight. What that means is, once you accept that the amendment was informed by a policy decision to curb capital flight, if that was the underlying reason, which the minister does not tell us, and the judgment says we must have regard to it. So if that was the case and it was incidental that revenue was increased, then we permit that. Now, contrast that to what actually happened here. The minister says for no reason other than to raise revenue, I am going to effect this amendment. So I've hopefully put that to bed. And the court does not have to get into a judgment of the merits and the demerits of those submissions. It's simply to ask, have I given you prima facie rights, even if open to some doubt? Have I shown you the damage? The minister has confirmed what the danger is, which was the EFF's own position, and was saying it's an irreversible damage. Counterbalance that with the minister's, he's a constitutional functionary. Much is made of outer and his powers. He's a constitutional functionary. So even if you limit his powers because the Constitution tells you must, then you must. It's also of no answer to say chances are the minister will fail in Parliament because now the EFF is playing GNU numbers. The fact of the matter is then that is the will of the people. That's the constitutional order. So even if this country runs into ruins worse than the fiscus, then that was a decision of the public, duly representing them in Parliament. And those are my submissions in relation to Part B. And I think I've covered the elements of the interim interdict. I'm not too sure if I'm leaving anything out. I'm really indebted to this court for the fan, for the indulgence, for giving me an ear.
Costs?
Costs are...
Normal, anything after the ordinary?
No. Well, we're submitting firstly, clearly the EFF comes here representing wider interests. Section 38, we've pleaded that. And therefore, Watch must protect the EFF. In relation to the minister, we ask nothing more than costs, including those of due counsel, nothing punitive. As a complete list.
Our submissions are what they are.
Now 10 past 2.
She just told me now it's 4 o'clock. I'm not too sure if I'm going to move it, but it's set for 4.
It's set for yours, Mr. Chairman.
Coming up. What time is the flight?
We land at 9, so it must be 7.
7. But your attorney is local. Do you have a local attorney here?
No, I mean, I'm not pressed to leave Justice. She could leave because she's giving the face. Then I'll stay with the correspondent attorney. I'm not pressed to leave.
So you don't have a problem with it. But if you want to be excused because you need to get a flight back to Johannesburg,
I'm happy then to have Mr. Masubika.
No problem with your junior is from Cape Bar.
Indeed.
And he can sit in. So if you need to leave. We should let you know. Just give your numbers so you can grab a cup of coffee somewhere. On both sides, you can register one number. We're going to come, or at least one of us will be coming back to court. Can't give you time, but I'm sure it won't be less than an hour for us to discuss drafting order and coming in with the order. But if you leave cell numbers on both sides, we can send you a message to say we're going back to court, this is the time. And then you may be excused as the motor examining flights and forward. And travel safely.
As a good place. Thank you. Okay.